Stand. Oyez, oyez, oyez. All persons having business before the Honorable, the United States Court of Appeals for the District of Columbia Circuit are admonished to draw near and give their attention, for the court is now sitting. God save the United States and this honorable court. Be seated, please. Case number 21-7127 et al. Exxon Mobil Corporation versus Corporacion CIMEX S.A. Cuba, appellants, Corporacion CIMEX S.A. Panama, and Union Cuba Petroleo. Mr. Krinsky for the appellant, cross-appellate Corporacion CIMEX. Mr. Davidson for the appellate, cross-appellant, Exxon Mobil Corp.
Good morning, counsel. Mr. Krinsky, please proceed when you're ready.
May it please reserve 4 minutes for.
Would you do me a favor and can you lower the mic a little bit? Yeah, I think.
Better?
Yes, thank you.
Maybe the 2 mics at the side also.
Okay.
All picking you
Okay,
up.
here we go.
Perfect.
Better? Yeah.
Yep.
Okay. Thank you. A plaintiff, ExxonMobil, sues for trafficking in expropriated property under Title III of the Helms-Burton Act. In 1960, Cuba expropriated an oil refinery owned by SOSA, a Panamanian corporation, and a subsidiary of Plaintiff, and also its auto service stations in Cuba. The property remains the property of the Cuban state itself. Plaintiff alleges that the Council of Ministers of Cuba put defendant Coupet's predecessors into possession of the property, and then Coupet for its operation, and that it did the same with respect to the auto service stations and CIMEX Cuba, the defendant CIMEX Cuba. We argue that the expropriation exception alone controls this action, and therefore the district court should have dismissed the action rather than, as it did, continue the action under the commercial activity exception. We argue that the expropriation exception alone controls the action for basically 3 reasons. The first is that the acts upon which Coupet and CIMEX are being held liable are part and parcel of Cuba's exercise of sovereign authority, and therefore the case belongs only within the expropriation exception. The second reason is statutory construction. The third is international law. As to the first, liability under Title III, Coupet and CIMEX's liability under Title III arises from their possession or their use, or both, of the expropriated property. But in having the property in their possession and using it commercially, they are simply exercising Cuba's exercise, they're simply implementing, I should say, Cuba's exercise of sovereign authority. It's sovereign authority over the disposition of its own property. It's sovereign authority over the disposition of expropriated property. And it's sovereign authority to place this property within its social economic system by keeping it within the state sector.
Mr. Krinsky, can I ask you, in just pushing forward under the expropriation exception, is it your view that Barcelona Traction forecloses the possibility that Exxon might have rights under what we call municipal law in the international law context, that it might have rights under, let's say, Panamanian law? No.
Well, I think it doesn't matter. I think the question, in a sense, doesn't matter because it does not have any rights under international law, Panamanian law, or property rights under international law, Panamanian law, or U.S. law.
Well, I'm thinking to the extent that shareholders have a right to consent and the expropriation was taken in violation of that right. I mean, if the argument is Barcelona Traction forecloses a finding that this expropriation was in violation of international law, I guess the question is, does Barcelona Traction cover the situation in which it might actually, the shareholders' interest might actually rise to the level of a legal right that is taken?
It would be probably right, Your Honor. On the Panamanian law, which I know plaintiff has raised in one sentence in its reply, only in its reply brief. I do want to point out that we believe that was waived. We argued Panamanian law did not provide rights in the district court. We put in an expert affidavit.
Understood.
Did not decide.
Understood, but on its merits, were we to reach it?
Excuse me? Yes, I do not think Barcelona Traction precludes there being shareholder rights under municipal law. I don't think, personally, the point wasn't raised and wasn't argued and was waived, and it's really serious. We put in an expert affidavit, and there was no response at all from the plaintiff. But the provision itself is the right that was given under that provision was not taken away. They still had the right as shareholder to authorize or not the board of directors to dispose of its property for whatever property they had. It's similar to the situation with the Barcelona right of shareholder right to residual assets after liquidation. Well, if there's expropriation, there's less residual assets, but still your right to the residual assets that remain as a shareholder were not taken. So we would argue on a point that was never raised before that this right under Panamanian law. The other point is that...
but then it sounds like you are saying that Barcelona Traction precludes the recognition here of any municipal shareholder rights under Panamanian law. For example, the right to consent. Sounds like you think that is foreclosed by Barcelona Traction.
Well, it is
for the reason that you just said, they only have the right insofar as they have the property.
It's precluded by Barcelona Traction in this sense, Your Honor. I would say that it would not. Barcelona Traction recognizes that in municipal systems and its customary international law, there's a basic separation between the right of the corporation and the right of the shareholder. If you would take a provision such as what we're talking about that they cited in their reply brief, and we construe it as upsetting that basic structure, then I think it would be in conflict with Barcelona Traction, Your Honor.
You started talking about Title III, and now you're flipping into some notion of international law. Isn't international law totally irrelevant to a claim under Title III?
It's not irrelevant, Your Honor, to the Foreign Sovereign Immunities Act.
No, I know. But under Title III, I mean, one of the things you said is this is not property under United States law. Title III is United States law, isn't it?
It is indeed, but only create...
And let me finish. One of the findings that Congress made in passing Title III was that international law was inadequate with respect to the confiscations that were occurring in Cuba. And I think it's sub 8 or sub 9 or sub 10, all those findings. And property is defined as including securities in Title III. So Title III, it seems to me, number one, does not depend on international law. And number two, defines property in a way that's absolutely inconsistent with your argument.
Well, first, Your Honor, to go back to what I was starting to say, Title III did not amend the Sovereign Immunities Act.
Not what?
Did not amend the Foreign Sovereign Immunities Act. There was a provision in it originally to amend the Foreign Sovereign Immunities Act, but it was withdrawn. So we are left to apply the Foreign Sovereign Immunities Act. Congress determined that any action under Title III against an agency must meet the requirements of the Foreign Sovereign Immunity Act.
Where does that determination come from? I don't see that. I've read Title III. You say that Congress determined Title III is subject to the immunity requirements?
Yes, Your Honor. There was a provision in the bill that said actions under Title III are exempt from immunity, and it was withdrawn. So
which bill?
It was in the House. Well, the House bill was what originally went forward.
It could have been withdrawn simply because it was unnecessary. And the reason it was unnecessary is the same reason we gave in the Mower case, that this is not simply a cause of action. It's an action that says that the Cuban agents are liable if the property has been confiscated and is being trafficked, which is namely being used. And that defines what the liability is.
In our, Your Honor, the reason why there was a waiver of immunity on the basis of that statute is that otherwise that statute would be a dead letter. It would be meaningless. It would be senseless. That's not so here, Your Honor. Plaintiffs can sue. In fact, plaintiff has sued under Title III within the constraints of the Foreign Sovereign Immunity Act, and its requirements must be met. One of the requirements is that there be a particular kind of right at issue under the expropriation section, a property right. Title III only gives damages. It doesn't create a right in the property.
Have there been non-state defendants in Title III cases?
There are a ton of them, Your Honor, in Florida. Yes, Your Honor. And they are different than us because they entered into a relationship with the expropriated property, if you will, through a simple contractual relationship. Carnival Cruise docks at a wharf in Havana and disembarks its passengers over a confiscated wharf. But that is separated from the
And there's no
exercise of sovereign
FSIA.
authority.
There's no FSIA issue in that kind of case.
Exactly.
Because
This is the first case. And I would point out the agency provision of the Title III doesn't apply just to Cuba. I mean, French state agencies, English, Canadian, so forth, all of which are
Title III
within the ambit of Title III.
Title III only applies to Cuban confiscation.
No, Your Honor, I don't believe that's true. Any person who traffics in confiscated property.
Oh,
The person is defined as
but the expropriation has to have been done by the Cuban
Yes,
government.
Your Honor. Yes, it's a Cuban bill.
Yeah.
Sure.
And you
Cuban.
keep talking about sovereign authority. I don't think there's any dispute about sovereign authority. The United States has sovereign authority to take property. The question is whether it's a violation of international law to take the property and not compensate the person that owned it. That's the question. It's not the question of exercise of sovereign authority.
I believe that's right, Your Honor, and that's why the expropriation exception applies. Under the expropriation exception, and it alone is where Congress said, we are going to make a weighty decision that we are going to allow a suit on the basis of a sovereign act.
But when you say, I mean, obviously you don't think the expropriation exception is met. When you say it applies, what you're saying is there's only one conceivable way
Yes,
that this suit can go forward and would be under expropriation.
We don't concede.
Why is that?
We spent 20
Because-
pages arguing it was still a violation.
Right. I mean, but why, I don't understand why that would be the right way to read the act. Even if you could conceive of this case as an expropriation case, and obviously there's ways in which one could. The statute, Title III even talks about the original expropriation as distinguished from the ongoing trafficking. It could be conceived of that way, but there's also another exception that's potentially in play. It just seems like the natural way you read that statute is that there's multiple exceptions. You kind of go down the list and see if any of them applies.
That may be the case that may be the situation in other cases, Your Honor, but I would suggest this is fundamentally different because, and the reason is really expressed it wrong in Wynnewood, reflects the same fact. There is no separation here between what the agency is doing that makes it liable and Cuba's exercise of sovereign authority. Wrong and Evenko recognize the state's transfer of the expropriated property to an agency for commercial use is a sovereign, not a commercial act. Well, if one end of that same transfer is sovereign, then surely the other end has to be sovereign as well. It's part and parcel of the same sovereign transaction, a transfer of property. And here, what's more, it's the transfer of the state's property. So, I mean, if the United States put part of the Colorado River in the hands of the Tennessee Valley Authority, the Tennessee Valley Authority fully carrying out its mandate, that's a sovereign exercise of authority. Not how it carries it out,
But Mr.
not a contract, not an independent act, but it is part and parcel of the same sovereign exercise of authority.
What about DeCepel, where there was a sovereign act of confiscation, but then we've applied the commercial activities exception?
Because there was a contract. They were suing on a contract, on a bailment agreement.
But here there's trafficking.
But here
Here
there's
there's trafficking.
trafficking.
It's
There's
just-
trafficking. There's
Well, it's
use of expropriated property to run a business.
Yes, Your Honor, but that's different than,
And the bailment, there was a bailment that arose as a matter of law. It wasn't like they wrote it out.
there was a bailment, well, matter of law or not, there was a bailment. Here, there is nothing more than the state, the agency having in its possession, being put in possession of property and being told to use it for commercial use. It's not about how they are using it. It's not about how they are, there's no independent tort. It's not about a contract. It's nothing independent from that exercise of sovereign authority. I think the district court went off in the wrong direction when it asked whether the act is in connection with a commercial activity. But Nelson settled that, well, if the act is sovereign, it doesn't matter whether or not it's a connection with a commercial activity, it's still sovereign. And that's what we have here.
So suppose, for example, that what happens, the trafficking that's alleged, the commercial trafficking that's alleged involves the issuance of bonds. And the action is that, well, you issued some bonds and now you're reneging on the bonds because you're extending the time frame. And it all happens on expropriated property. I mean, it's obvious under Weltover that it would be the commercial activities exception.
Yes, Your Honor, but yeah, it would be indeed. That's how the state participates, or the agency, how the state or the agency participates in the marketplace. What we're talking about is the sovereign decision about not how you participate, but who participates in the Cuban economy with what property. And those are sovereign acts. What if Cuba had issued a regulation that said only state enterprises can use expropriated property? But surely we would recognize that's the flip side of Weltover. That's the part that Weltover recognized as sovereign. Well, that's what essentially they did. Instead of passing, there probably is a regulation somewhere, but they probably, instead of passing a regulation saying only state enterprises can use the oil refinery, they gave it to the oil, they gave it to a state enterprise and said, you possess it, you run it. It's the same exercise of sovereign authority.
But I don't think the question is who. I think it is how. For example, in the DeCepel case, I think the government of Hungary made an argument about the trains and the museum being part of the state. And we looked at the function, not at the who, but at the how, but these are things that can be in our functions that can be in our carried out commercially. And that seems like that's a robust and well-established strand in both the Supreme Court's cases and ours.
That maybe have been the facts, Your Honor, the arguments, but the decision rested very explicitly on there being a bailment agreement. A bailment agreement is a contract, comes within a restrictive theory of immunity.
There are many contracts by these state enterprises. CIMEX is entering into contracts.
But that's not what makes them liable. What makes them liable, what Helms-Burton does, is makes them liable for possessing property given to them by the state or using the property given to them by the state.
Right, and using
the property that was given to the state.
I know, but still, it's used. It could be a subsequent purchaser, a subsequent person who has control over the property, and using is just commercially using it in the way that any private party might selling goods.
It's not a private party when you're carrying out the state's exercise of authority, of sovereign authority, to dispose of its property, dispose of expropriated property, to keep property within in the public sector. Look what we would be saying if this is not a sovereign act. We would be saying that Cuba cannot, in its exercise of sovereign authority, structure its economy to have its oil refinery, key industries within the state sector.
So even if we were to accept this argument, the upshot of which is that the relevant acts in issue are sovereign acts.
Yes,
you can still apply the commercial activity exception and reach that conclusion. You would just say under the commercial activity exception at the first step, it doesn't constitute commercial activity. It sounds to me like that's the upshot of your argument. That doesn't mean that you only apply the expropriation.
I think not, Your Honor. I think if the act is sovereign in character, which we maintain it is, it doesn't matter whether it's also in connection with commercial activity. In Tehran, Your Honor, I mean, which was where a stronger case than in Tehran. In Tehran, there was the state's property, and there was actually a contract, a concession. And then there was allegedly a breach of that contract. This court nonetheless said this is within the expropriation exception, not the commercial activity exception. Here we're stronger. There's no contract. They're not suing on a contract. They're suing on the core, bare, naked, sovereign act of the agency being told, here, you take this property and you use it commercially. And that happens all the time. That's exactly what happened since 1917 with expropriated properties.
Is Tehran
a state enterprise?
Is Tehran a precedential decision of this court? I'm sorry, I don't know why my microphone is not effective, but is Tehran a precedential decision of this court?
No, Your Honor, I think not. But I think it illustrates the point that when you're dealing with the state's own property, and the state disposes of it the way it wants to, then that is a sovereign act.
So can I take you, just to go to another step of the argument. I know you made an enthusiastic and forceful submission that we have to do this under the expropriation exception and that it's a sovereign act. But let's just assume for argument purposes, you'll resist the assumption, but assume for argument purposes that not persuaded by that. I'm not saying I'm not, but let's just assume that I'm not for present purposes. And we apply the commercial activity exception. Yeah. We're in that.
Yes, I'm glad Your Honor appreciates the time.
Yeah, and so on that, let me just ask you the question. So the district court had two particular channels through which it concluded that the commercial activity exception was satisfied, one of which was the remittances and one of which was the sale of U.S. imported goods at the stations. And just to focus on the remittances for a second. So on the remittances, if it's true that the SOSA, is that how you?
SOSA.
Yeah, okay. If there's an entire program that's designed to get remittances from U.S. persons so that persons from the U.S. can send funds to persons in Cuba. then does it not just necessarily follow that there's a direct effect in the U.S. as a consequence of creating and maintaining that program?
The problem is that there were only 4 to 10, and most 4 to 10 out of 504 remittance locations on SOS land. Only 4 to 10 out of 500.
So on that, if that's your main response, and that doesn't surprise me that would be a main ingredient of your response. So let's just suppose that in those, let's just assume 4 to 10. I mean, I think there'll be a response that says, well, if there's more discovery, maybe we'll find out there's more than 4 to 10. But let's just stay in 4 to 10 land. So in 4 to 10 land, if one of those 4, let's just give you the benefit of the 4. If one of those 4 is processing millions of dollars in remittances, then you're past the triviality threshold of Weltover at millions of dollars. Well, Weltover tells us it doesn't need to be substantial. Then why isn't that enough? Even if it's only 1, I'll just give you the benefit of 1. Why isn't it enough? We don't know how much any particular station is processing. Why isn't it enough?
Because it's, I respectfully honor, it's the wrong question.
Okay.
The question is whether the 4 to 10 was the cause of the remittances flowing. And the district court did not make that finding. It missed the boat. And what we think the court should do is either remand for the court to address that question of whether the 4 to 10 is the cause, we say proximate cause, but it really doesn't matter for this moment, is the cause of the remittances flowing. We don't think it's plausible 4 out of 504. And by the way, Exxon has a list of remittance locations. It could say if it's more than 4 to 10, but they haven't said that. So the question is the causality.
But causality, the 4 to 10, I get that for purposes of Title III. But for the FSIA, all that matters is if the act causes a direct effect in the U.S.
But did it?
And the
district court never addressed the 4 to 10. He didn't address it. He respectfully missed the boat. He said, well, there was a contract between Western Union and CIMEX, a related company, opened up a channel of communication and remittances flowed. But the question then is, did the 4 to 10 cause, part of the cause, we say approximate cause, but anyway, cause Western Union and CIMEX enter into that contract? That's the question. And because it's the contract that makes the remittances flow. And that there's 4 to 10, we say, is the district court didn't say it, and Exxon doesn't even allege it. Exxon does not even argue. Didn't argue below, didn't argue here, that the 4 to 10 were a cause of opening up this channel of remittances. The district court asked the wrong question. It didn't focus on the 4 to 10.
Suppose it's 100%.
I think that would be a harder question, Your Honor.
Let me just finish. I'm not asking if it's a harder question. I'm asking whether under your argument, you would still say, even if every single facility was one in which remittances were coming from the U.S. to Cuba, are those facilities causing the remittances to flow?
I think we would have to ask, Your Honor, whether there was an intervening act, an individual independent assessment by Western Union or whether it was really relying on those 504 locations. I think that would be the factual inquiry. It's a hard, but as I come back to, I understand the premise of the question.
Excuse me, I'm hung up on this, and I'm sorry to interrupt you, but I've been overseas and received Western Union wires, and in facilities, but it was always Western Union had a separate office. Is that the same in Cuba with respect to these 7-Elevens?
There's a sign on the door, on the auto service station door. They sell gas, and there's a sign on the door that says Western Union.
But is there a Western Union office in there with a Western Union?
Western Union appointed CIMEX as its agent in Cuba to distribute remittances. And
Okay.
CIMEX appointed 3 sub-agents to do that. CIMEX is one of them. There are 5, the 3 sub-agents provide 504 locations. Only 4 to 10, you can imagine the number here, 4 to 10 is on SOS land. on the
So
expropriated
just,
land.
just following up from Judge Randolph's question, it's more like when you buy a lottery ticket from a retail outlet in the United States. They have a sign on the door that they sell them. You go to the cash register and they will process the lottery tickets from their, just as part of the products that they sell, right? So it's not a separate office.
No, it's not. It's
But it is I mean, what I find challenging for you about the commercial activity exception, both with the foodstuffs and with the remittances, is 2 things. The Title III claim is very broad. The Title III authorization for a private right of action using the expropriated property in putting it to commercial use, very broad. And then the type of outfit that we have here, these sort of convenience stores that do a lot of things, including, in some cases, process remittances, sell various goods, including, the evidence suggests in some cases, U.S. goods. So it seems like maybe an unusual case, but why shouldn't we find that the direct effects on the U.S. of purchasing U.S. goods and processing U.S. remittances are related to the gravamen of the claim, that commercial activity of running convenience stores, and the direct effect of doing so insofar as if they weren't running those convenience stores, at least some of that type of business would no longer be coming into Cuba.
Yes, Your Honor. Maybe that should be the finding, but it wasn't the finding. The district court didn't focus on the right question. Where is the causality for using the expropriated property? And maybe the district court will decide on the evidence, on the current evidence or on additional evidence, that it is, the causality requirement is met, but the district court didn't do it. And so we should have at a minimum, we should have a remand for the district court to look into the facts and make that finding. Because there is no finding of causality from the use of expropriated property. That is what has to cause the direct effect. There's simply no finding.
Do you draw a distinction between remittances and the sales of U.S. imported goods with respect to this point you just made, that the district court, in your view, didn't make the right finding in terms of causation?
Well, I think the key on the foodstuffs is that the district court said that further factual development might lead it to conclude that the foodstuffs were not a direct effect. It stated that explicitly. And he said, well, so far, what you've given to me is not enough to dismiss this action. But it explicitly said further factual development might lead me to a different conclusion. And so a remand for that purpose, as well as the purpose I just mentioned on the remittances, seems to me entirely the appropriate.
Well, why do we need to remand at all on the foodstuffs if the district court is already going to do what you're saying we should remand for the district court to do?
I'm sorry, Your Honor.
I thought what you had just said is that the district court is already saying that it's going to conduct further discovery on the foodstuffs, and that further discovery might end up reaching a resolution in your favor. Why would we remand for the district court? I mean, why would we need to tell the district court anything on foodstuffs if it's already going to do what you think it should?
I think that's a fair point, Your Honor. It's in a peculiar posture because it's interlocutory, but I think on the Western Union, it's quite different. I think the court should identify the issue which the district court should look at and decide upon, which is whether there's causality based upon the use of some service stations to pay out Western Union remittances.
And are you asking for a reversal and entry of judgment in your favor on jurisdiction, or are you just saying it sounds to me that the primary submission you're putting forward is that you ought to have a chance to go further in the district court to meet your burden to show that the exceptions to the FSIA are inapplicable.
We argue, Your Honor, first, of course, that the expropriation exception alone controls, and that ends the case.
Got that.
When we get to commercial activity section with respect to CIMEX, which is the only party that the court reached on the commercial activity exception, that we do argue that on the record, the judge should have dismissed the claim under the commercial activity exception. We also argue that if the district court, if that's wrong and it shouldn't have dismissed, it shouldn't have denied the motion, and it should continue to examine the question which it failed to recognize as the key question.
I have one more question.
Yeah.
And it deals with the Foreign Claims Settlement Commission.
Yes, sir.
Right. Well, why isn't that a waiver or an exception to any sovereign immunity that Cuba has, that the federal government has authorized a commission to award damages against Cuba, and in fact did it to the tune of, what was it, $71 million? When was that, 19 what?
The commission was set up in 64, I think, and that decision was probably 67. But it wasn't a decision.
But why isn't that a waiver or a disregard of Cuba's sovereign immunity?
It's not an award to the plaintiff. It's a certification to the Secretary of State for possible use in diplomatic negotiations with Cuba, state-to-state negotiations. It's not a award. You can't sue on that. It's a certification to the United States, to the State Department.
Well, you can now. You can sue on it now.
No, I don't.
Title III entitles you to a presumption that your property has been taken and the amount of damages awarded by the commission. That's a suit on that award, isn't it?
But you have to show it's your property, and they haven't shown it's their property.
Well, not under FISA, but certainly it showed almost conclusively a presumption that it was their property. Otherwise, the commission could not have rendered the award.
The presumption you're referring to, I believe, Your Honor, is about the amount of damages. But the Foreign Claims Settlement Commission did was fine, as was totally within its statutory mandate to tell the Secretary of State. What it did was that Exxon, as a shareholder of a corporation whose property was expropriated, suffered indirect economic injury, damages. Well, maybe it did. Maybe the Secretary of State someday will raise that with the Cuban government, but that's not a property right. And remember when we were talking, Helmrich made it very clear, we're talking about a particular kind of right here under the expropriation section. We're talking about a property right. The indirect economic damages is not a property right under international law, Barcelona Traction, Panamanian law, under any other.
Under Title III, you know how property is defined under Title III?
I have read it, Your Honor.
Yeah. The term property means any property, including patents, copyrights, trademarks, any other form of intellectual property, whether real, personal, or mixed, any present, future, or contingent right, security, or other interests therein, including a leasehold interest.
But those
and you say that doesn't cover the loss that Exxon claims?
No, those are SOSA's property. Those are SOSA's property. It owned the property. It had all these things. The question becomes, and the notion that this shareholder has a property interest in the corporation's property is flatly contrary to Barcelona Traction, and all that plaintiff can rely on is lex specialis, treaty provisions negotiated to get more than what customary international law gave.
Can I go back to just and then we'll give Exxon a chance to argue, unless my colleagues have further questions. I just have one question on commercial activity. And on commercial activity, and put aside remittances for a second, and let's talk about the foodstuffs. CIMEX has a supply contract with Allenport, and Allenport gets goods from the US, and then CIMEX ends up taking those goods and selling them at the stations, as I understand it, at a high level of abstraction. Is the reason that CIMEX has a contract with Allenport so that Allenport can get goods from the US, since Allenport, as I understand the record, is the only entity that can import from the US?
CIMEX's contract is not for Allenport to get goods from the United States.
I know that's right.
Allenport, I think it's important to note. I mean, Allenport imports food from the entire world for the entire country of Cuba.
I get that. I guess my question is this, though. I think I do understand that, and I appreciate the clarification. But because Allenport, as I understand it, is the only entity that can import from the US, it may import from all over the place. But because it's the only entity that can import from the US, is the reason that CIMEX has an agreement with Allenport so that CIMEX at least has access to US goods, since Allenport is the only entity that can get goods from the US.
There's nothing in the record that CIMEX cared at all where the food came from. It has a supply contract for, not these auto service stations. CIMEX wants many, tremendous distribution network. It says, we want, in the coming year, we want, 50,000 chickens. It doesn't care where the chickens come from. There's nothing in the record indicating where the chickens come from.
And
so then you have the question of causality.
Isn't Mr. Krinsky, isn't Allenport also the exclusive importer from elsewhere? It is the importation arm, no?
Yeah, well,
if CIMEX wants to import from Spain, does it go through Allenport?
Yeah, probably, Your Honor. Again, there's nothing in the record that it's a little bit more complicated.
Okay.
So Allenport is by far the major importer of food from around the world from Cuba.
Is it not entirely foreseeable that as a result of CIMEX's purchase orders, Allenport will import goods from the United States?
I would say, Your Honor, on this record, it's entirely not foreseeable. Allenport makes its own, the record is, and maybe with further faction, and I think that's the district court's alluding to, wanting to have more development. The factual record is Allenport makes its own decision, totally independent of whether CIMEX or anyone else is going to carry the goods, about how much of the country's needs it's going to import from the United States or from, and it's mostly overwhelmingly not from the United States. So the question.
And when you say it's mostly overwhelmingly not from the United States, do you mean with respect to the service stations or with respect to CIMEX as a whole?
The whole country.
Do we know with respect to the service stations?
No.
We don't know.
We don't know. That's not in the record. No. And the record on foodstuffs, I would suggest, is seriously underdeveloped. And the district court, for decision, and the district court recognized that.
Make sure my colleagues don't have further questions from you. We'll give you a little time for rebuttal.
Thank you.
Thank you, Mr. Krinsky. Mr. Davidson.
Just the mic. Morning. Hey, please the court, Stephen Davidson for Exxon Mobil Corp, the plaintiff below, appellee, and cross appellant. And I will discuss our response to Mr. Krinsky's appeal and our cross appeal, reserving a couple minutes of rebuttal for our cross appeal. As is clear, there are, according to Exxon Mobil, two pathways for subject matter jurisdiction here. One is under the FSIA and the two exceptions we say apply, the commercial activity exception and the expropriation exception. Another is a direct case under Title III itself. And I'll take up that argument second, but that argument is that under Title III, there has been a waiver of sovereign immunity, and that we don't need even to resort to the FSIA. We can just deal with Title III. The judge below ruled against us on that point, and we pled in the alternative as to both relief under the FSIA and Title III itself. And within the FSIA, we said two exceptions apply, the commercial activity exception and the expropriation exception. So turning first to Mr. Krinsky's appeal and our response to that, we would submit that the district court got this right on the commercial activity exception, and principally by focusing on trafficking, because trafficking is what we are entitled to sue under. Not possession of the property, but sue as an American citizen, sue those who traffic in our property. And I believe the district court in his ruling was correct when he said, quote, the act does not grant a cause of action for mere expropriation of property. Rather, liability under the act attaches only when a U.S. person's property has been confiscated and trafficked. Trafficking in expropriated property is the gravamen of the Title III claim. We would submit the district court correctly relied on Sachs in dismissing, as you heard in argument this morning, the one element approach as flatly incompatible with the court's precedent. And, Your Honors, the trafficking activity we have sued under is fundamentally commercial. The remittance program, the foodstuff program. So we would submit we fall squarely within the ambient of the commercial activity exception. And as I think was mentioned earlier in argument, the breadth of the definition of trafficking and property under Helms-Burton is very broad. It includes a wide range of covered commercial acts, as well as a catch-all provision for engaging in commercial activity using or otherwise benefiting from confiscated property. And then if you look at this court's precedent and the Supreme Court precedent, we believe we fall squarely within those decisions with respect to the commercial activity exception. We principally rely on weltover, direct effect when money was paid into the U.S., sovereign acting as a private commercial act, successful, which has been discussed and raised by Judge Pillard. It involved expropriated property, but still there was a commercial activity. And then we would look at your direct effects jurisprudence, principally in Cruise Connection and the AIG Energy case.
So in our cases, we have said that nothing in the FSIA commercial activities exceptions direct effect requirement requires that the direct effect harm the plaintiff in the United States, which is helpful to your claim. But I don't think we've ever found a direct effect where the act upon which the action is based, the gravamen, the direct effect that it has in the United States, doesn't even harm, doesn't cause harm in the United States. Is there harm in the United States from the Cuban market being available to United States Western Union, to United States foodstuffs?
Your Honor, I would respectfully submit that that question is phrased too narrowly in connection with your precedent. The direct effect can be manifested through what Judge Mehta called, and I think is also in the EIG case, a direct negative economic effect. That is funds flowing out of the United States or funds that were supposed to be paid into the United States and weren't. So it's not so much, with all due respect, I wouldn't necessarily characterize it as harm. I would say effect. And I would fasten onto the word effect because that's the word of the statute, not harm. And your jurisprudence allows for there to be a negative economic effect. And I think if you look at how Judge Mehta analyzed the record and analyzed these two.
When you say negative economic effect, do you mean unharmful economic effect?
Negative, I mean, I guess negative and harmful are relatively synonymous, but negative in the sense that money flows out of the United States or money that should have flown in doesn't, like in the bonds case.
Well, it's over. But those are really two different things from the perspective of negative. If the U.S. is supposed to receive funds that it doesn't receive, well, that's both a non-action, so negative in that sense, but it's also bad for whoever wanted to get the money. Whereas here, it's a non-action in the sense that the goods are, the demand is being created to pull goods out of the United States, but it's not adverse in any sense because, as I said, it's a bigger market for the purveyors of those foodstuffs and remittance
But I think,
services.
Your Honor, what direct effect requires is that there's conduct specifically, economic conduct specifically targeted at the U.S., and that there is an effect in the U.S. of that. And I would submit that harm isn't necessarily what the FSIA is aimed at with respect to direct effects, because as Your Honor mentioned, there are cases under the FSIA where simply being harmed isn't a direct effect. Like, you know, there are a number of FSIA cases in which a plaintiff sues. I mean, one could say in SAC, you know, the plaintiff is injured in the United States, but that's not a direct effect. It's not necessarily harm, it's an economic effect.
I mean, in your view, in other words, it seems to me that your argument is that it could be a beneficial effect because the purpose of the FSIA exception is to establish enough of an economic nexus to the U.S. that it seems fair to hail the defendant sovereign into U.S. court. And even if it's a beneficial effect, that's still an effect of the kind that justifies bringing the sovereign defendant into U.S. court. Is that
Yes,
your view? So you don't. So your answer to Judge Pillard would be, I think that even if the cases don't deal with situations in which there hasn't been a harm, it doesn't matter because even if it's a beneficial effect, it's still an effect for the language of the statute and for the underlying purpose, which is to make sure that there's enough of a commercial nexus to justify bringing the sovereign defendant into U.S. court.
I would agree, and I would also remember we're dealing with a fairly novel situation in that the actual cause of action is for trafficking. So this case, in some ways, is unlike FSIA cases that have preceded it because it's on this special kind of cause of action of trafficking rather than, you know, a breach of contract or other kinds of things. It's a very broad remedy that applies to a lot of different conduct.
Is there another case, per Judge Pillard's question, is there another case where it actually went in this direction where one could conceive of the commercial consequences as being beneficial to the U.S., but nonetheless, it's the basis for establishing jurisdiction?
Well, if you look at the Weltover case, I mean, there was direct effects. I mean, not all, I mean, some of the bond payments were made. So there was money going back and forth. I mean, ultimately, they sued when a bond payment was missed. But I would submit that the direct effect is still satisfied, even if a bond payment is made.
Just stepping back, I take it you agree that the effect, the act that causes the direct effect in the United States has to be the act that is the gravamen of the claim. So here it's the running of the use of the commercial use of expropriated property to run the series of convenience stores in Cuba.
Right,
so that is the gravamen.
Right. It's the, you know, trafficking. And then here, we would say that translates into the use of the confiscated property for these commercial purposes. And
Right.
remember, the property we're talking about with respect to these two, the foodstuffs and the remittances are these confiscated service stations.
Right. Now, what about this what just appears to be quite incidental amount of remittance business that is run through the CIMEX owned, and the particular stations that, at least as far as defendants can tell, that were the stations that were expropriated from SOSA 4 to 10.
A few points in response to it. First, you know, the one the Chief Judge pointed out that we haven't had discovery. We don't know actually.
Did you preserve a claim that you need discovery on that?
Yes. But we believe that, you know, to sort of have our cake and eat it too, it's also unnecessary because 4 to 10 is enough.
Why?
But why? Because remember, the standard here is non-trivial. And let's talk about the remittance program. In the 2018, there was $3.6 billion.
Overall, do we know the quantity through?
We don't. And there are But from the evidence and below, there are 66 Western Union machines or remittance machines at CIMEX stores, and defendants have admitted that 4 to 10 of those are in confiscated service stations. That's the record. And then the question is that non-trivial? There's literally billions of dollars going into these 66 or the 502 remittances, 66 of which are at service stations. Any one of these 4 to 10 could be hundreds of millions of dollars a year in money that's going through. And I would submit it's very unlikely it's not in several, if not tens of millions of dollars. And the question is that non-trivial? And we wish the record in some ways was better, but we, of course, don't have access to these stations. The discovery wasn't, the judge said we have enough to find non-trivial without doing this discovery.
Would it matter whether it's part of CIMEX's business plan or whether it's only part of, what is it, CIMEX?
CIMEX.
That some of these remittance receipt sites are in service stations? I mean, it seems to me that it's clearly part of CIMEX's commercial use of the property that it sells foodstuffs.
Right.
Less clear that it is sort of part of the program of CIMEX in running these, that it allows people to pick up their remittances. Are they accommodating somebody else's business plan? Does that matter?
Well, CIMEX, I mean, it might be CIMEX, but an entity in the CIMEX chain has a contract with Western Union to provide these remittances. And they decided that it's in these service stations, among other places. There are 500 locations in Cuba, 66 in service stations. So I would submit it's part of their plan to have these in service stations to allow for greater convenience and greater use of the remittance stations.
Do we know whether these 4 to 6, I don't think we do, but are rural, remote, or
I don't know the answer to that
major
question, Your Honor, as to where the 4 to 10 are. But we would submit that the judge was right, that it's non-trivial.
What's your response to CIMEX's argument that the way to look at the 4 to 10 is to ask whether that small number of stations, and I mean small relative to the overall number of stations, actually causes the outflow of dollars from the U.S., of funds from the U.S. to Cuba?
Well, we know that they, by their own admission, there are 4 to 10 that use the Western Union remittance program. So I think we can take as a given there is some money flowing. So the question, only question in my mind is, does that get over the non-trivial wall? Because it's certainly flowing. And as I said in response to Judge Pillard's question, we believe the judge was right. It's clearly non-trivial.
But is that really answering the question in the sense that if the gravamen of the claim has to cause the direct effect, then wouldn't the question be, would this, I mean, it seems reasonable at least to assume that the same amount of remittances would be sent and that the people in Cuba who are picking them up would just have a very marginally fewer choices about where to do that. So isn't there some at least modeling needed to say whether there is any effect on the outflow of remittances from the United States of the availability of these 4 to 10 stations? At least that's what I take, the defendant's argument on this to be.
Well, I think to the extent we're getting into the purpose, I think the case law is clear that we don't necessarily have to look at
Just
the purpose.
cause a direct effect. That's what I'm focusing on. Does it cause this effect?
Again, there are 4 to 10 of these stations where, I mean, could you, I guess your hypothetical or your question presumes, well, if there weren't those 4 to 10, would the money still go anyway?
Right.
Yeah, same amount of money.
Well, the first answer is I don't know, because these 4 to 10 may be in some place where the people who use them can only access them there. Maybe they don't have a car, they walk there, or, it's on the other side of the island. So there are plenty of explanations as to why the 4 to 10 are essential to some amount of commerce being transmitted. And I think one could perhaps take the logical progression that if there are fewer of these, there'd be fewer transactions and less money transmitted. But I don't know, frankly, if the standard would be so exacting that we would have to prove absent the 4 to 10, would there still be monies? I mean, I think what we need to prove is what we did prove and what the judge found, which is 4 to 10 is non-trivial.
Do we have any idea what the transactions are between Western Union and CIMEX? I mean, does Western Union rent space, or do they pay a license fee or whatever?
I don't know the exact particulars of that relationship.
Well, I wonder whether it matters, because it seems to me if there was a fee, somehow or another, rental or leasehold or whatever, that if it's not turning a profit, Western Union would shut it down.
Well, I mean, I think it's a given that Western Union makes a profit on it. I mean, they charge a fee for the transmission that comes out from the sender or the receiver. And I don't know whether CIMEX has to pay Western Union a fee or vice versa for using their facility.
And
Can I ask?
no, you go
No,
ahead.
I was going to shift to foodstuffs if you have.
Yeah, so would I. Go for it.
Oh, okay. So if we just shift to foodstuffs for a second.
Sure.
A couple of questions. First, just as a setup, does foodstuffs matter if there is jurisdiction by virtue of remittances? And let's just, I suppose practically it could matter, because if in further discovery it turns out that the remittances doesn't work, then you might need foodstuffs. So I take that point. But just if you divorce it away from that, does it matter? Does it add something to the substantive Title III claim so that we should reach that issue? And second, if we do reach it, then on foodstuffs, why isn't it significant that Allenport is making, as far as the record now shows, entirely independent decisions about where the goods will come from, and that CIMEX, from everything we can tell from the record, doesn't care whether they come from the U.S. It's just by virtue of the independent decision of Allenport that anything from the U.S. is being sold at these locations.
As to the last point, Your Honor, I would submit, with all due respect, that's not what the record says.
Mm-hmm.
Judge Mehta says, CIMEX, quote, exercises some degree of discretion in carrying U.S. goods for sale in its convenience stores. CIMEX specifies the products and their amounts that it will purchase from Allenport. And that's in the joint appendix to JA 2073-74.
Right, but that I don't understand why that answers that, because all of that could be true. And what CIMEX says is we want X product here. I don't care where, I don't, frankly, just being a consumer, I'm not sure I get why the seller wouldn't care where the beer comes from or even what brand it is. But let's just stipulate that that's what the record says, because I think it is what the record says. And they just say they want a product. Name the product. I don't care where you get it from. I don't care what brand it is. I don't care what company manufactures it. Just go get me that product. And at that point, I don't think CIMEX is saying we care or is doing anything to indicate that it cares whether the goods come from the U.S. That's all an independent decision by Allenport.
Again, Your Honor, not to quibble, but the record, I don't believe so. The record says CIMEX exercises some degree of discretion in carrying U.S. goods.
Well, of course they do, because that statement just doesn't mean. But you have to, I don't think you could just point to the statement in the district court opinion, because the district court has to be relying on something. And I don't think that statement taken at face value tells us that CIMEX actually cares whether something comes from the. Of course, they have discretion. I mean, they could tell Allenport in their negotiations, we do or don't want good from the U.S. We do or don't want, Tyson's chicken as opposed to something else. We do or don't want Budweiser. They could do that, but so they have the discretion. But I don't think, as I understand the record, based on that second declaration, the state of the record is that CIMEX just doesn't tell Allenport anything about what brand it wants or where the product is supposed to come from. It just gives it a finite number of a particular product. And it's entirely, let's just assume that that's right. It's entirely Allenport's decision on where to get it from. If there's something in the record that tells me otherwise, I'd be curious to know what that is, but I'm not aware of what that is. And if, besides the district court statement, because that's, for me at least, that's not persuading me that the record says otherwise. So either let me know what in the record says otherwise, or if not, why is it still enough that CIMEX does? I think everybody agrees CIMEX ultimately does sell goods that come from the U.S. That absolutely is going on. But CIMEX apparently doesn't care whether the goods come from the U.S. That's all Allenport.
Right. Well, as to the record,
yeah,
the Valmana Declaration is what we have, which is at the Joint Appendix to 2074. And according to her, American products reach CIMEX shelves only when CIMEX is placed in order for goods. Allenport, in turn, buys some of the goods CIMEX has ordered from the United States, and CIMEX makes a business decision to carry it. So I think, Your Honor, in response to the factual predicate part of your question, that doesn't probably carry me all the way home in that CIMEX is making a decision to buy products from the United States.
Right.
But they certainly know that's happening, and they're not stopping it. And they're shelving, and they're stocking their shelves with these products that come from the United States. So I would say it's more than just happenstance, because to use your example, if they didn't want to stock Budweiser, they could have said, stop bringing that from the United States, but they don't. And they know that products are brought from the United States. Money is going into the United States, which we would submit that commercial exchange as a direct effect. And also, Your Honor, I would direct your attention to the EIG case, the Brazilian Petrobras scandal case. The investment loss was actually booked in Luxembourg in that case. But the funds ultimately came to rest in the U.S. And you remember from that case, the court said it doesn't matter if these ricochet around the world, so long as there's an effect found in the U.S. From that, I would submit, Your Honor, that the courts are not as concerned or mindful of this sort of purpose element. It's like, was there a direct effect in the United States? How did it come to happen? And even if there are other effects, or even if there's this ricochet effect, it's still enough. But
it has to be direct still. And I guess, and that's where the rubber hits the road on this, I think, is whether it's a direct effect of the act undertaken by the defendant. And if the act undertaken by the defendant is the sale of goods on its property that were imported from the U.S., does that act have a direct effect on the U.S. where the defendant, based on the existing state of the record, isn't caring whether the goods come from the U.S.?
Well, to me, Your Honor, the answer to that question is, and I hate to answer the question with part of the definition, but is there actually a direct effect? Mm-hmm. And whether they purposely bought U.S. products or sort of were happy to buy U.S. products or happy to shelve them, the question is, was there an effect here? And under the sort of definition that I was working with you, Your Honor, Judge Millard, that there is, because there's this commercial exchange, funds flowing in, and an impact in the U.S., an effect in the U.S.
Do we know whether CIMEX has to use hard currency from any foreign country from which it buys goods? Or are there countries where it doesn't have to use?
I imagine it.
Dollars.
It has to use to buy the products from the U.S. I'm certain.
Right, but I'm wondering whether it has any reason to buy less from the U.S. where it can because of terms.
I don't know.
Yeah.
And then
so we haven't talked with you about the expropriation exception and in violation of international law, and I haven't heard from you how you deal with the problem of international law's distinct treatment of shareholders from the SOSA property owner itself and the Barcelona Traction hurdle. And there's some, claims that some of the arguments that you have raised in response are arguments that you did not preserve. And I would just like to briefly hear from you.
Sure, let me do that. But if I could, the one question I didn't answer of yours, Your Honor, is do we have to have both?
Yeah.
Either one is sufficient, in my view, for there to be a direct effect. We'd like to have both because as lawyers, we always want more. But either one would be sufficient in our view.
But does it affect, so why would you like to have both? Let's suppose, just by hypothesis, CIMEX will resist it, but just to carry out this hypothetical, let's suppose you win on remittances.
Mhm.
Does it matter to you at all? And let's suppose that win is immune. It's invulnerable. Does it matter to you at all for purposes of litigating your Title III action, whether you also win under the foodstuffs?
In that hypothetical, I don't think it would. I mean, as lawyers, we're almost never willing to make that assumption.
I'm just wondering what the legal consequence is for litigating your, or even practical consequence is for litigating your Title III action, which is what we have ultimately, of having more than one foundation for jurisdiction under the FSIA. It seems to me that you think that as long as you get in the door under the FSIA, it could be one gas station that's doing remittances of a non-trivial amount. And then as long as you have that, and as long as that doesn't get overturned at some point, then your Title III action just goes forward as it would.
I believe that is so, but we haven't reached that point.
Sure.
We're defending them both.
Yep, okay.
So, Judge Millard, in terms of the expropriation exception, again, just to set the stage, that's our second basis under the FSIA claiming immunity to sue these agents or instrumentality. And the question in particular is what we have complained of a violation of international law. I mean, we'll deal with that element. There are other elements to the exception, but that's really the one that's before you. Before we even get to Barcelona Traction, we would say, the point we've made throughout the proceedings and in the brief below, is that one element of international law, in terms of finding whether this is a violation of international law, is that the taking is not discriminatory. And before we even get into shareholder rights and Barcelona Traction and what we can sue, this taking was discriminatory. If we look at Cuba law number 851, which is the operative statute that took the property, which is at the joint appendix at 1127, that was specifically targeted at American companies and particularly mentioned the plaintiff. So we would submit, even under Barcelona Traction, Helmrich and Payne, and the remainder that talk about the entire enterprise exception, or the requirement of there being an entire enterprise. We don't even need to get there because this was a discriminatory taking.
But you
violates
do.
International law.
But you do, because it violates international law. And the question then becomes, whose international law rights did it violate? And under the distinction between the corporation and its shareholders, it would seem to be the corporation's international law rights. So the corporation, even though it's Panama SOSA, it violates Panama SOSA's rights that its property was taken for a reason that had to do with discrimination against its American owners. But that doesn't change the nature of the shareholders' rights as distinct under Barcelona Traction and Diallo and the international law generally, right? So it doesn't get you around that problem, Barcelona Traction problem.
Well, but even if it doesn't, into that, Cuba has unlawfully interfered with Exxon's direct right as a shareholder. By
How so?
interfering with our beneficial ownership and control of ESSO and by denying Exxon the economic value of its shares. So we would submit that as a shareholder, we've been injured and by this
But that's just the diminution.
By this discriminatory take.
Right, that seems like that's just a diminution. And unless there's something that you're asking for in terms of inquiry into municipal law, Panamanian law, that would fill out our understanding of what the shareholders' rights were and how they were in fact obstructed. I don't see the distinction yet from Barcelona Traction.
Well, we can also question whether Barcelona Traction sets an immutable rule that it has to be an entire take. In that case, they posited that there needed to be, but I'm not sure if international law so requires, and that our indirect rights as a shareholder are at issue. And I believe that under international law, which we've cited in our brief, and, and particularly in relying on the ICSID cases and the Iranian Claims Tribunal cases, that our indirect interests are recognized.
A lot of those have to do with rights that flow from a bilateral agreement, and that the particular is agreement, not international law writ large. And so if we discount those for that reason, you may have a response to that, but let's just suppose we're discounting for that reason. There's still the question under what everybody agrees is international law of whether the entire interest has been essentially annulled. And on that, as I understand this course of proceedings, you never made an argument about that in the district court or in our court until the reply brief.
I think that's fair, but the evidence we relied on was defendant's own evidence, which in fact was put into the joint appendix by defendants.
But I think what really for forfeiture purposes, even if the evidence was there to be had or an argument to be made on the basis of it, we expect parties to make the argument.
And I understand that, Your Honor. And I would submit here that given the knowledge of this evidence and the facts that have been before the parties, that any notion of undue surprise or other types of procedural argument would not be well found.
So you're requesting that we would not deem that argument to be forfeited here?
Correct. And that's,
you want to finish your
Let me just finish on that if I could, Your Honor. Just, and that the issues related to that have been, put before you in their motion to strike and our response and in the potential survey.
Okay, does FISA or Pfizer or whatever you go contain a definition of property?
Does the FSIA contain a definition of property? I'm not sure, Your Honor. But
suppose it doesn't. And why then should not property be defined in accordance with Title III?
Your Honor,
for purposes of making the determination about whether the property has been taken in violation of international law. You have to have some idea of what is meant by rights and property. And but I don't see why the definition has to be in terms of some amorphous international law when you have a definition of property in the very statute that gives you the cause of action at a minimum.
Well, we would agree, Your Honor, and push that point a little further too.
And I might add that the definition of property is employed in Title III for the purpose of determining whether there's been an expropriation, whether there's been a confiscation.
Right, Your Honor. And then the Claims Commission had certified that amount, and then Title III gives us a right to sue to enforce that right. And if I could talk briefly about Title III, as you know, an alternative basis that we've posited is that we have subject matter jurisdiction under Title III. The Title III itself gives us a right to sue without regard to the FSIA. So that if we were correct, we wouldn't even need to deal with these questions of exceptions under the FSIA. And our argument is fairly straightforward on the Helms-Burton Act's subject matter jurisdiction. One, it allows for suits against agencies or instrumentalities of foreign government. And, the 28 U.S. as codified in 28 U.S.C. 6082, it goes who are entitled to sue. And we're entitled to sue any person. And that person is defined to include an agent or instrumentality of a foreign state. So, but that isn't alone enough or the extent of our argument. The question then becomes, because there's obviously ample jurisprudence, starting with Armada Hess and other cases, that say the FSIA is the only basis under which you can sue a sovereign. And there are cases like Armada Hess and others where they have found that other claims can't be brought outside of the FSIA. Here we would submit this is a circumstance under which, even with Armada Hess, that we should be allowed to proceed with subject matter jurisdiction under Title III itself.
The district court relied upon that case, I think was decided in 1989, where the Supreme Court said that the FSIA is the sole source for allowing jurisdiction over foreign sovereigns. And it does seem to me that that's a misnomer in itself, because I don't see sovereign immunity as a jurisdictional question. It can be waived, but the court was a lot looser in those days in labeling things from jurisdiction. But nevertheless, that was decided in 1989. This statute came into effect in 1996. So the statement by the Supreme Court, which has been repeated, but could not possibly have anticipated a suit against of the sort that you're bringing now under Title III. And the other thing that I'd like you to address is that the fact of the matter is that the Title III is a specific statute aimed just at Cuba. FISA is aimed at the world. And there's a doctrine of interpretation that says that the specific controls over the general. And I'm not sure that you've made that argument, but I'd like you to address it.
Well, yes, Your Honor. We believe that as a later enacted statute after Armada Hess, which is the 1989 case, and with it specifically tailored to this precise situation, that it doesn't run afoul of the Supreme Court's teachings on FSIA. And in fact, if we dive more deeply into Title III, I think that position becomes even clearer. Because if you assume, as the district court did, that we can only sue under the FSIA, there are a number of references within Title III that would then be unnecessary. And I don't think we should conclude that Congress put unnecessary references. For example, in Title III, there's a particular provision that says, as to a sovereign, it's in the procedural requirements section of Title III, which is at 28 USC 6082C. There are particular provisions there that have been added to deal with service of process on a sovereign. In that section, the Congress said the service of process over an agency or instrumentality of a foreign state shall be done like it is under Title 16, in 1608 of Title 28. In other words, the FSIA. So, and similarly, there are provisions in this procedural section that deal with attachment and execution against Cuban property. 6082D deals about enforceability of judgments against the Cuban government and says, if there's been a regime change, you can't enforce a Helms-Burton judgment against the new government. And there was a provision that was in 608, in Section 302E, which then became 6082E, that became codified in the FSIA that dealt with certain property of the Cuban state that could not be attached. That is diplomatic property.
Diplomatic missions.
Right.
Yeah.
So,
facilities used.
So my point is, if Congress intended plaintiffs like us, in order to sue an agent or instrumentality, had to go under the FSIA, it would have been completely unnecessary to put these other provisions in Helms-Burton. Because in Helms-Burton now, there are specific provisions that say, if you sue an agent, one, you have the right to sue an agent or an instrumentality. Two, if you sue an agent or an instrumentality, these are the things we've taken from the FSIA that you have to follow.
And three, it assumes that a judgment will be enforceable, which is contrary to the idea that sovereign immunity would protect against that.
Because as you know, under the FSIA, there are a number of provisions that deal with how to enforce a judgment against a sovereign or its agents or instrumentality. If we were only to follow the FSIA, these provisions that I'm going through would be unnecessary. And there's also a catch-all provision that describes the interplay between Helms-Burton and the FSIA in Section 1, 302C1.
Why is it, I don't understand the unnecessary point. I mean, for example, C2, which is service of process, and it says you'll serve process as process is served under the FSIA.
Right.
I mean, it might be unnecessary in the sense that you're just doing what the FSIA says you should do for service of process, but it's also not doing anything different. So it's entirely consistent with having the FSIA as the font of jurisdiction.
Here's what I take from that. If what the district court said is actually the law, that we can only sue under the FSIA, and that Helms-Burton did not create a ability to sue a sovereign, you wouldn't need to put these provisions in because they are already found in the FSIA. What I would submit is that the reverse is true. Congress knew that we could sue an agent or instrumentality without regard to the FSIA. So what they did was they imported a handful of provisions from the FSIA and put them in Helms-Burton. Because if they didn't do that under our view of the world, we'd be able to execute on our judgment against Cuban diplomatic mission because it's not otherwise immune.
Could you go against another sovereign under Title III?
If another sovereign was trafficking in our property.
Yeah. Do you think that Title III, if it's Title III is an additional font of jurisdiction entirely regardless of the FSIA, as your argument presupposes, suppose some other sovereign comes into possession because of some agreement with Cuba of property and is engaging in trafficking on that property, you get to go against?
I think that one, I would think the contemplation would have been that Cuba is the only sovereign in town when it comes to the Helms-Burton Act. And then your question would be hypothetically, if another sovereign was trafficking in expropriated property, could we sue them without regard to the FSIA? We would submit it does create a cause of action.
No, you couldn't. You could not sue another sovereign. You can't even sue Cuba under this.
We can just sue an agent or instrumentality.
Yeah, that's right. All you can sue is an agent or instrumentality.
The person is defined as an agent or instrumentality.
Okay, an agent and instrumentality of another sovereign.
Let's say of Venezuela,
Still the
to whom Cuba has sold some, oil infrastructure.
If it were an agent or instrumentality of a foreign state.
Would that proceed under Title III, I think the question is, or would that proceed under the FSIA?
Well, we haven't considered that possibility yet. We would submit that Title III gives us a right to sue. I think in that situation, the question would be, did Congress contemplate a waiver of sovereign immunity with respect to someone other than a Cuban agent or instrument?
Well, if the Cuban government had brought in some entity from Russia to operate the oil refinery, I don't see any reason why you would resist that. I think it's absolutely covered by this.
I mean, it would fall under the definition of person, and Congress did not make any other provisions with respect to certain Cuban, other non-sovereigns, but we would have, in that hypothetical, Your Honor, we would have to follow the provisions that are imported to Title III from the FSIA, like venue. And remember, there are other provisions.
It's not so hypothetical, by the way, but that's another.
Right.
So can I take you back to a question I asked earlier and apply it to this too? On this axis of your argument that there's an independent basis for getting jurisdiction over a Cuban entity via Title III, does it matter to you whether the way you get to go forward in your Title III action is that Title III creates jurisdiction or that it's a remittance at one station that gets you under commercial activity? Does it matter?
It doesn't matter, and it would be, we would prefer to go simply under Title III because then we wouldn't have to deal with the commercial activity and the remittances, all these other things with respect to the creation of jurisdiction. So
why would you? But I don't understand why you'd prefer it. I'm just to give you the cleanest hypothetical. I'm just hypothetically guaranteeing you a win under one of these. Do you care?
No.
Okay. I just wanted to understand the way you were conceptualizing this vis-a-vis.
I like the Helms-Burton argument, but no, I don't.
Yeah. Okay.
So if I could save a few minutes for rebuttal.
Let me make sure my colleagues don't have additional questions at this point. Sure.
Thank you.
Thank you. Mr. Krinsky, we'll give you 3 minutes for rebuttal, and we'll give 3 minutes for the cross-appeal rebuttal.
Thank you, Your Honor. want to try to cover a couple of points. On direct effect, what strikes me is that a lot of the inquiry, a lot of the argument is on a question that Judge Mehta did not find. What is the effect, if any, caused by the 4 to 10 service stations? What is the effect of CIMEX carrying these goods on their shelves? And there's a whole lot of, and we say on the record, we should have won on both points, but in any event, he did not make the findings which are necessary to sustain direct effect. And so at a minimum, we would suggest a remand for that. Those determinations is necessary. Let me see. Also on the direct effect, Judge Mehta did mention trivial, but that wasn't in the sense of causation. He assumed incorrectly, as error, we believe, that setting this Western Union and CIMEX setting up these channels of remittances was the effect, and the remittances flowed. That was, as a result of that, that was the effect. And then the question he asked was the amount of those remittances trivial? But that's not the question. The question is whether Western Union and CIMEX setting up these channels of remittance, the direct effect of CIMEX using these 4 to 10 stations. And so the trivial point he addressed is actually a different point. As to the 4 to 10, I want to make it clear on the record, we have not admitted that there are even 4 to 10. What we said is there are no more than 4 to 10 because we've looked at the property records, and except for those 4 to 10, we see no trace of SOSA land. We haven't admitted even 4 to 10. On the question, on the Barcelona property right question about the taking of the property by the entirety. Judge Mehta did make findings on that, and on the basis of absolutely sufficient evidence. He said management and control was not taken. That stayed with SOSA, with Exxon as its shareholders until 2012. And he said because there was property and business outside of Cuba, and he pointed to Panama and Jamaica, the entirety of the business was not taken. Exxon's ownership of the corporation had not been completely destroyed. And that's the standard the United States has maintained, and which Helmrich accepted. Its shares were not useless. It was still operating this company. So on the question of rights under shareholder rights, it seems Judge Mehta has laid that to rest with his findings, unless the plaintiffs can argue it was clear error, and it was not clear error.
Thank you.
On this business of Title 3 and the service division, the answer is easy. It was abundance of portion. Title 3, when that provision was put in, it was when the jurisdiction of Title 3 was changed from exclusive federal jurisdiction to state court concurrent jurisdiction. And so out of abundance of caution, Congress may have been concerned that state courts would not issue default judgments without paying attention to the service division. And in fact, it had been warned by the State Department there were going to be lots of default judgments, again, by agencies. And so
there's no concurrent jurisdiction.
Yes, there is.
If you bring a case under Title 3, there's a provision in Title 3 that bars you from bringing an action under common law, any other federal law, or any state law.
But it can be brought in state court. Title 3 lawsuits can be brought in state court. They have been brought in state court.
But it have to be under Title 3.
Under Title 3?
Yeah.
Yeah. I think to address your question about whether Exxon should care about whether the judgment is under Title III of the FSIA. Well, I think the answer is that they should care, because if it's under Title III, they cannot obtain execution on the judgment except by conforming with the FSIA's provisions about 1609 establishes immunity from jurisdiction, except except when the judgment is under one of the specified exemptions from suit. So Title III judgment gets them no execution, Your Honor. Two other points, and because
You could be brief, please.
yes, and two other points I don't even, just to mention them, Your Honor. On the expropriation exception alone controls, we argue statutory construction and we argue international law, and we do believe they are both really quite important. Statutory construction, expropriation exception addresses this very conduct. Agency engaged in commerce, operating expropriated property. And it lays down very hard, specific conditions for a lawsuit on that. Commercial activity exception doesn't address that. It's literal terms, it sweeps as far as operation of expropriated property, and yet without the conditions that Congress has imposed. One pitch for international law, Your Honor, we suggest that in this area particularly, it is really important and should be paid close attention to. Allowing suit by a former owner, which Exxon is not actually, but allowing suit by a former owner against an agency for using expropriated property commercially, I think we have demonstrated would be contrary to international law at the time of the FSIA's enactment. There was no abrogation of immunity for that. So we would be placing this lawsuit well beyond a radical departure from customary international law. Thank you, Your Honor.
Thank you, counsel. Mr. Davidson, we'll give you. Okay. Thank you. Thank you, counsel. Thank you to both counsel. We'll take this case under submission.
Case number 22-1015 et al. Wynnewood Refining Company LLC and Coffeyville Resources Refining and Marketing LLC petitioners versus Environmental Protection Agency. Mr. Houston for the petitioners, Mr. Hughes for the respondent.
Morning, counsel. Mr. Houston, please proceed when you're ready.
Okay, please support Michael Houston, Perkins Coie on behalf of the petitioners. EPA admits at Joint Appendix 12 that it created the extension rule because it had missed multiple statutory deadlines that are critically important to the administration of the RFS program. Now, under this court's decision in Americans for Clean Energy, EPA's several statutory violations do not entirely foreclose it from setting a renewable fuel volume obligation. But they do trigger an obligation on EPA to make sure that it reasonably considers and, quote, minimizes, in the words of this court, the harm to the obligated parties. But the extension rule makes things worse for the petitioners, not better. It does that in three principal ways. First, it violates Congress's instruction that there must be at least a minimum of 13 months lead time between when EPA sets an obligation and when the petitioners are required to comply with it. Second, EPA compresses multiple, quote, calendar years worth of obligations, in the words of the statute, into a matter of just a few months. And third, EPA entirely destroys the value of the critical deficit carry forward provision. The statute entitles the petitioners, for any reason, to put off their obligations until another, quote, calendar year. But under the extension rule, our clients can only put off and carry forward a deficit for just one more quarter. The predictable result of all of this is that RIN prices have skyrocketed, and the extension rule does nothing at all to address that core harm on petitions. I'd be more than happy to answer the court's questions, but otherwise I think it might be instructive to take a moment and explain how we got here.
Can I just ask, you say that as a result of EPA's rescheduling actions, RIN prices have skyrocketed, but that's a more complicated matter, is it not? You know, to know exactly what the causal agent is of a price rise?
So, Judge Miller, just because I think the thing that has caused RIN prices to rise is not the extension, it's the late action. And I think that the very best evidence of this is actually the GAO report, and I really encourage the court to read this, particularly at pages 9 to 13 and 24 to 25. It explains in detail precisely why EPA's own officials told the GAO in the course of that report that they understood that when they were very late and then acted, that had a, quote, substantial impact on RIN prices. I think EPA knows that this happens, and it's just really a matter of simple economics. When EPA comes and for the first time ever requires a number of small refineries to comply with the RFS program by denying hardship, and it says you're going to have to meet multiple years worth of obligations over just the next 14 months, EPA is spiking demand for RINs, and it's doing so in a situation where the supply of those RINs is already fixed. Because remember, we're talking about blending that has already occurred in prior years. We're talking about all the RINs that have ever been, that is possible to generate for 2019, 2021, 22. They've been generated. It's a fixed supply. And yet EPA's action, by being so late, they have created this massive demand. They forced the petitioners to go out to the market and try to buy those RINs.
I don't understand why that has anything to do with the rule that you're challenging. You talk about compliance, but the rule you're dealing with is when you have to file a report on compliance in a previous year, with respect to a previous year, right?
Well, when we have to actually comply, Judge Randolph, I mean, there's a reporting obligation too, but the extension rule is setting the deadline by which we have to actually comply with the statute, when we have to turn in
It's when
the
you
RINs.
have to file the report. It used to be March 31st of the following year, right?
Yes.
Now you have two other options. The date on when the quarterly report is, et cetera, et cetera. Suppose you win here, right? That means if you haven't filed your reports yet, you're not in compliance. It reverts back to the previous rule. This gives you an extension for filing reports. That's all it does. It doesn't change whether EPA followed the 12-month rule or 13 or 14-month rule or any of that. It just deals with when you have to file a report.
Respectfully, Your Honor, I don't think that's quite right. We're talking here about years that have already gone by. The deadlines that the statute would have enacted for our clients to demonstrate compliance with the RFS obligation, those have already passed.
Exactly.
But that is EPA's fault. They are the ones who declined to put out the volumes on time, to deny the hardship petitions on time. We obviously couldn't comply when we didn't know what our compliance.
And they're acknowledging that, and they're trying to mitigate.
They say that they are, Your Honor, but I think our core submission is that they are not doing so. And they're not doing so in really three reasons. I think if the court looks at the Americans for Clean Energy decision, which is the last time that we were here. And by the way, I think it's just worth emphasizing, this is the fourth time that refineries have come to this court to talk about EPA needing to get back on track because it had missed statutory deadlines. So this is not a situation where, as my friend from the APA says, agency resources are limited and like sometimes something slips through the cracks. We're talking about an agency that over several years has been late over and over and over again.
Yeah, I want to go back to a question. I mean, you answered a question that I asked. Maybe I misheard you. You said this rule does more than simply give a deadline for when the reports are due, right?
Yes.
Yeah, well, here's the title to the rule. It's annual compliance reports, report submission deadlines. The submission deadlines for annual and quarterly reports shall be as follows. That's the rule, right?
Yes.
It doesn't say anything about anything else except when you have to file the report.
The report is a proof that we have complied, Your Honor, that we have turned in RINs. That's what the extension rule is all about. We have to turn in our RINs to EPA, and then we have to file a report that proves that we turned them in. So the operative, what the extension rule does, the real meat of it, is it sets the deadline by which we need to have the RINs in hand. But again, the statute...
It sets a deadline what on?
It sets the deadline by which we need to have the RINs for a particular compliance year. Each year, we have a renewable volume obligation, and there's a deadline by which we have to turn them in. Now, EPA has missed all of those deadlines, so the extension rule is resetting that. But it's violating the statute in two ways when it's doing that.
Why isn't this a mitigation measure in the terms of what the ACE court required? It's a mitigation measure because EPA has missed the deadlines and it's giving you more time to file your yearly annual compliance report.
Because, Your Honor, it is not mitigating any of our core harms. And so if the court looks, as I'm sure the court will, at the Americans for Clean Energy decision, you will see that there were three principal reasons that this court concluded in ACE that EPA had mitigated the parties' harm. First, it had ensured that they had a reasonable path to compliance. Second, it had ensured that there were enough RINs out there in the market that petitioners could go out and acquire them. And third, EPA had made sure that parties would be able to take advantage of the deficit carry forward provision. That's the mitigation that this court described at pages 722 and 723 of the ACE opinion. But none of those things are available to us. We asked in the course of the extension rule for a remedy, for a type of remediation that would make it possible for us to comply. But EPA rejected our request. We do not have a responsible path for compliance.
But can I ask, so put aside the carry forward for a second, because I think at the outset you mentioned three things. The carry forward was the third, and then there were the other two, which had to do with the time periods.
Yes.
The 13 months and the 12 months, I think,
Yes.
is what you're referring to.
That's correct.
And with respect to ACE, isn't it the case that also with the rule that was reviewed in ACE, there could have also been made the same argument about the 13 months and the 12 months?
So for some of the deadlines, right, there were, of course, a number of deadlines that were reset in ACE.
But at least for some of them, that the same argument could have been made.
The same argument could have been made, Your Honor, but I want to stress it wasn't.
Right. I take that point. And so you could say that, well, ACE would have come out differently as to those years if that argument had been made. But I'm just trying to establish the predicate that, in fact, what was upheld in ACE was something that couldn't have been upheld under the argument that you're pressing today.
I think that's right, but I don't think that's surprising. I mean, the court cannot be faulted for not engaging with arguments that the parties before.
Sure, but I just want to establish the point that you and I think analytically all of that makes sense. But the practical result is that under your argument today, ACE was wrongly resolved, not decided based on arguments that were presented, but the rule in ACE shouldn't have been allowed to be sustained.
I think that I would express the point just slightly differently. I think that the rule that EPA put forward in ACE was unlawful for reasons that were not presented to the court in ACE. And thus, what I think is emphatically clear is that ACE does not stand for the proposition that our statutory arguments are wrong because the arguments weren't made to the court. So the court doesn't typically weigh in on questions that aren't presented to it for good and substantial reasons. And so when no party made this argument to the ACE court, ACE doesn't foreclose the argument just because there was a problem. It's akin to a sort of drive-by ruling that sometimes...
I mean, ACE did talk about the time periods for compliance.
Yes, but they were critically different, Your Honor. In ACE, what the court said was important was that EPA had given the petitioners 15 months to obtain compliance. And in many cases, even more than that. For again, there were 4 deadlines in H, and each one had a different time period. But when the court looked at this, it said, we think 15 months is more than enough time for you to go forward. You know, and maybe they were right about that. But the statutory minimum is 13 months. And that is, I think, the one provision of this statute that is just expressly clear.
Well, there's no provision that says 13 months.
Well, I agree that there is no provision that says 13 months, Your Honor, but I mean, there is a deadline by which EPA has to set the volume, and it's November 30th. And then we have the following calendar year. I think if you just put those two provisions together, there's no way to say that we're not required to have at least a minimum of 13 months.
If you get till the, I mean, you think it's inconceivable that there could be a compliance deadline during the compliance year?
I'm sorry, I don't think
So it's 13 months if you say you start with November and you get till the very end of the year.
Yes.
Is it not, it would be flatly inconsistent with the statute if EPA had a compliance deadline that was during the course of the year?
Absolutely, Your Honor, for 2 reasons that I think are clear from the text of the statute itself. First, 754502A1 talks about the fact that the way that you calculate our obligation has to be on, quote, an annual average basis. And then second, of course, we have to demonstrate compliance over the calendar year. So taking Your Honor's hypothetical, if EPA had promulgated the volumes in November, but then said you're going to have to demonstrate compliance in July, we can't comply with that mandate in July without, we're not going to be able to demonstrate that we conducted the appropriate amount of blending on an average annual basis.
Why not? Why couldn't you have, I mean, one might think in the old days that a regulated party here would be putting RINs in their account as they import or refine the fuels. And if they're doing that as they go along, then they're not going to be subjected to ebbs and flows in the, or spikes and valleys in the RIN prices. So maybe people don't do that anymore because they have leeway. And as you say, the compliance filing is not just a filing, it's actually some action coming, or has come to mean some action coming into compliance. But let's say EPA thinks that that's problematic for some of the reasons that you point out about the spikes in the RIN market, and it decides, like the IRS does with respect to taxes, let's have quarterly filings, and yeah, we'll true it up at the end. Anything in the statute that prevents that?
Yes, absolutely, Your Honor. 2 things, I think. The first, again, is that we have to demonstrate compliance on an average annual basis. And then the second thing is the deficit carry forward provision. The EPA has some flexibility. It has discretion to push out deadlines beyond what they were required, but it can't supersede the minimum amount that it's guaranteed.
And so I guess I'm not sure why that's responsive to my hypothetical, because you could have the average annual and just have that worked out when you true up at the end.
Yeah, I guess that's conceivably possible, Your Honor, but there would still have to be that. I still think that means we're talking about 4 deadlines sort of over the course of the year. And really, just like in the tax context, you have one tax bill for the entire year. You might have to pay as you go that bill, but that's something very different from what EPA is saying. This is like saying EPA is saying you have to pay 4 years of your taxes, on date 1, and then 3 months later, and then 3 months later. That's a really
well. If you get an extension until October, and then you pay your next taxes on time, you have to pay your taxes, within 4 months of one another.
But
6 months at least.
I agree with that, Your Honor. But you had the minimum amount of lead time that the tax code in hypothetical guarantees you. And what they can't do is drop down below the 13 months of requirement. And then I think the other point that really drives this home is the deficit carry forward provision. The statute says that when we have any reason why we can't comply, we want to wait, it's advantageous for our business, whatever, you don't have to give a justification for using deficit carry forward. When the petitioners take advantage of a deficit carry forward, it's entitled to carry a deficit for an entire, quote, calendar year. I don't think that EPA has any discretion to take away that calendar year's worth of extra flexibility. And that's a critical piece of the bargain that Congress put into this statute. It imposes a very serious obligation on the petitioner.
Would EPA say you can carry over for more than a calendar year, or is that just statutorily limited?
The statute says you can carry over for a calendar year. I mean, I think honestly, Your Honor, that EPA probably could give us more than a calendar year if it had to do that. If it found reason. I think that the court can, the agency can extend deadlines beyond statutory minimums, but it can't drop below statutory minimums.
Did EPA not do that here with there's not the action that's directly under review, but I thought there's an alternate RIN. Did they not allow an additional carry forward period?
There is an alternative, a different rule. Your Honor is exactly right. We've challenged that rule too. I mean, I'd be happy to explain why we think that rule has very serious problems.
But just on this question of extension, I thought that that's actually what happened.
They have purported to extend some of the other deadlines even further. If I might just say one sentence about what's really the fundamental defect in that rule, it's based on the assumption that by that extra time and that taking advantage of other RIN vintages will make it possible for petitioners to buy RINs at a reasonable price. But it's just empirically false. The court can go and see that all of the RIN vintages cost essentially the same. In other words, the RINs that were generated in 2019 cost about as much as the RINs for 2020 and 2021 and 2022. So just changing the, what year's worth of RINs we buy doesn't help. It's the price that is the problem. And it's the price that is really the thing that EPA has made no serious attempt to address in the extension rule. The price is our biggest harm. EPA has to minimize that harm, but they haven't addressed anything about price in the extension rule.
I guess, why isn't that the obligated party's fault in not, doing the dollar cost averaging approach to RIN accumulation?
I'm really glad that you asked, Your Honor, and I would really like to just take one moment and sort of explain exactly why. I understand the instinct behind that question. The GAO report really helpfully explains why there was no responsible path for compliance. This is dealt with at pages 24 and 25 of the GAO report. They studied this precise issue. Kern Oil is one of the petitioners in this case. Kern Oil tried to do that. They said, okay, we're going to take what you might call the conservative approach. We're going to acquire RINs all along, sort of on the expectation that one day we might be required to comply. And if we get hardship relief, okay, great. But Kern Oil, by virtue of that business decision and EPA's mismanagement of the program, suffered massive business losses. And the reason was that Kern was acquiring these RINs all along, but then suddenly EPA, long after the statutory deadline, granted hardship relief. And it granted hardship relief to a whole bunch of other parties as well. And then it refunded their RINs. EPA said, here are your RINs back. Those RINs are worthless. And it was tens of millions of dollars in losses that Kern incurred. This was the subject of litigation in the Ninth Circuit. That's discussed in our reply brief. The Ninth Circuit found that EPA had violated the law in that instance because they had inflicted tens of millions of dollars in harm on Kern Oil. And they put forward a remedy that was designed to make Kern Oil whole. And that, I think, additionally speaks to my friend from the EPA's point that there's no response, that there's no remedy here. I think we've proposed a number of different remedies. We're talking about a situation for years that have already gone by. All of the blending that can be done for 2020 is already done. There's no benefit to the environment that could come from the extension rule. What we're now talking about is who's going to pay. And I think that Kern Oil puts forward one way that the court could design a remedy to address that, which would essentially require EPA to give a credit between the RIN price on the date that they should have acted and the RIN price today. Or,
go ahead. Finish.
Or the last thing, the alternative remedy is, I think, and the best remedy is the one that actually EPA put forward for 2018, the alternative compliance demonstration approach. EPA said, it's just too far gone. The situation in 2018 is so messed up that we can't unwrangle the knot. And so we're going to have an alternative approach. That's all EPA needs to do to get
the alternative approach, meaning you owe nothing.
They did not require compliance demonstration by requiring RINs. That's essentially correct, Your Honor. Now, I'm not saying that EPA has to do that. I'm not saying that's the only remedy that EPA can come up with. What I am saying, though, is that EPA exercised its discretion and found that in a situation very much like this one, years gone by, the market is not at all working the way that it was supposed to, as EPA acknowledges. The right thing to do is sort of stop, take a pause, press the reset button, and get back on track going forward. I'm sorry.
The question I had was, you mentioned a couple of times that we're talking about time periods that have already passed, so all the transactions were already undertaken and expectations have congealed and all that.
Yes.
As I understand it, EPA took account of that by basing its decisions, its backward-looking decisions, on the actual state of the market.
So 2 points about that. First, that's in a different rule that we have also challenged. That's not part of the extension rule. EPA, and I think that's part of the challenge that, in all candor, we are trying to comply with here. EPA is putting forth 3 and 4 different rules designed to address this problem. We, of course, can file a petition for review only for one rule at a time. But I want to engage with the point directly. EPA says, okay, that was our mitigation strategy. We reduced the volumes for this given year. They reduced them by about 15%, but it costs 10 times more today to buy RINs than the date that it would have if EPA had been on time with the 2020 volumes. So I think that when EPA has said, well, the price has gone up tenfold, we're going to give you a 15% haircut. I mean, the math on that obviously shows that we are much, much worse off. And I don't want to, I think it's important to give the court a sense of the scope of the obligation here. We're just one of the petitioners in this case. We're talking about obligations of $150 million for one compliance year, and then 3 months later, you need $175 million. 3 months after that, $183 million. So these are massive costs. This is our largest expense besides crude oil. It costs more to demonstrate compliance with RFS than labor for the petitioners. So these are extraordinarily imposing obligations. And when you're talking about an obligation, again, the scope of which went up tenfold in price because EPA was so late in missing statutory deadlines, the fact that they shaved 15% off the obligation is really just not going to address our fundamental harm.
Can I get back to a question that Judge Randolph asked? So the question had to do with what would be the upshot if hypothetically you were to prevail in your challenge. So if you were to prevail in your challenge, the extension rule, if you get vacated, would get vacated.
Yes.
And then does that set you back to a situation in which the compliance deadline then is the one by the upshot of your argument would be the statutory date,
So
the November 30th date, which has already passed.
Yes, it
and
would
so
have.
are you worse off?
No. If the court vacates the extension rule, EPA is going to need a new deadline. It's going to have to reset the deadlines again, but it's going to have to do so in a way that actually addresses and minimizes the harm that we're facing. So it's going to have to put, as you say, Your Honor, the statutory deadline for compliance has already passed. And the extension rule purports to, put a new deadline in. We think that's unlawful. If the court agrees with us, EPA will have to set yet another deadline in the future. But when EPA sets that deadline, and when it takes account of what is going to be required on that deadline, it's going to have to address the price. That's the critical point, because that's our harm. And so under Americans for Clean Energy, EPA has to responsibly study the actual harm to the petitioners and address that harm. That's what the extension rule doesn't do. And that's what I think would be the key, the massive benefit to the petitioners of a ruling from this court that vacated the extension rule.
Make sure my colleagues don't have additional questions for you at this time. Thank you, Mr. Houston. We'll give you a little time for rebuttal. Mr. Hughes.
Good morning, and may it please the court. Jeffrey Hughes from the Department of Justice on behalf of EPA. With me at council table is Meredith Miller. I'd like to highlight 4 reasons why, in issuing the extension rule, EPA reasonably exercised its authority to set compliance deadlines. First, the text of section 754502A3 directs EPA to issue regulations that contain compliance provisions to ensure that the requirements of this paragraph, that's section 7545H02, are met. Chief Judge Srinivasan, I think you mentioned the statutory compliance deadline, but in fact, the statute does not set the compliance deadline. That is set by
Regulation.
a regulation, exactly. This provision, section 754502A3, does not provide for annual compliance deadlines or any other particular interval. Second, in ACE, this court held that EPA reasonably issued delayed volume requirements because it, among other things, determined that obligated parties had sufficient time to acquire RINs to comply with the standards where EPA had granted compliance deadline extensions similar to those at issue here. Third, here, EPA determined that the intervals provided for the extension rule allowed obligated parties sufficient time to acquire RINs without overheating them. And fourth, this schedule will allow EPA to get back on the track set by the With respect to the text of the statute, the refinery's argument for inflexible compliance deadlines rests on a misinterpretation. The provision directing EPA to set compliance deadlines does not require annual compliance deadlines at all. EPA could require, as Chief Judge Srinivasan and Judge Pillard mentioned, quarterly compliance deadlines. Alternatively, two of the petitioners here argued in their comment on the proposed extension rule that EPA should require compliance for 2019 to 2022 at one time. That's in J16 to 17. I would also note that three of the compliance deadlines issued here, 2019, 2020, 2022, fall more than 13 months after the standards were initially promulgated, though the 2022 standards were subsequent. Next, regarding...
Wait, I didn't quite follow that point. What?
Yes, so the 2019, the annual rule was signed on June 3rd of last year. And the 2019 rule, but the 2019 and 2020 rules were initially promulgated in 2018 and 2019. And so since those days, well more than 13 months have elapsed between the issuance of the rule and the compliance that were in June. So less than 13 months has elapsed between the issuance of that rule and the compliance. With respect to 2022, again, the rule was signed on June 3rd of 2022, and the compliance deadline is, as we expect, would be September 1st, 2023.
So maybe I'm missing something, but if the other side's argument is not 13 months and neither lesser nor greater, but is just a minimum of 13 months and greater is fine, then what does that do to the point that you just made?
Your Honor, as I understand their argument, there must be at least 13 months between the issuance of the rule and the compliance deadline. And so for 2019, 2020, as initially promulgated, and 2022, they have that more than 13 months.
Mm-hmm.
And so you can set that, so that can be set aside for those particular.
What can be set aside?
The question of whether they've received the 13 months between the issuance of the rule and the
Is that what they're arguing? Are they arguing that, well, they also are arguing that there has to be an interval between separate compliance deadlines, or they're not arguing?
They are also arguing that there needs to be 1 year between compliance deadlines as well, Judge Pillard. I would just point out that, again, there's nothing in the statute that speaks to the amount of time that must elapse between compliance deadlines. I think we pointed out in our brief, EPA.
When you say compliance deadline, what do you mean?
The deadline by which the obligated party needs to submit its compliance report showing that
Report, right. It's not compliance, it's just a report of what happened.
Well,
Is that during is the year a calendar year, or can the 1 year annual be other than a calendar?
Sorry, is the question that our compliance years and annual years?
The compliance reports have to be filed annually.
There's no requirement that compliance reports in the statute be filed annually. By regulation, EPA has set it up such that compliance reports are typically filed annually.
Okay. You know, if you can simplify this for me, when EPA sets requirements and so the small refiners have to comply and then mix their fuel with 10% renewables or whatever, does EPA always do that before the calendar year in which compliance is required?
Your Honor, in this case, it has not.
So how can, if you set the, I don't know what this has to do with the extension rule, but if you set the requirement for 2022 in July, then how in heaven's name can a small refiner comply with that when they don't even know what the rule is until halfway through the year?
Your Honor, there are two reasons at least. First is EPA has suggested to, or has told the obligated parties that they should be ratably acquiring RINs throughout the year in order to make sure they can comply. So, so as they're producing fuel, as they're selling fuel, they should be acquiring RINs to make sure that they can comply with their obligation when the time is due. And also,
Can you talk louder? I'm missing a lot.
my apologies, Your Honor. The EPA instructs the obligated parties to acquire RINs as they're purchasing or importing non-renewable fuel, such that they'll have sufficient RINs when the compliance date comes. In addition, as this court has pointed out in the Monroe Energy case, through the years at issue here, the obligated parties have notice of what the volumes are going to be because they're laid out in the statute. Now,
That's another word that's kind of thrown around here. There's a volume for the entire United States about the amount of fuel that will be used in a year. You're not talking, when you say volume, that's not what you're talking about. I'm
talking about the volume. What the statute provides is the amount in Section 754502B provides the volumes of renewable fuel to be introduced into the transportation sector of the United States,
which you then convert to a percentage.
Which once that is once any waivers or adjustments are made, that is, and there's the amount of fuel used for the year is projected. That is then converted into a percentage, which obligated parties can use to determine what their obligation is.
I thought that the response was, I mean, you don't know how many RINs to set aside or purchase or have available until you know the percentage of the renewables that this annual standard requires you to mix in. And so you have blenders blending on old standards if the new standard's never been promulgated. And I thought the way EPA responded to that when it was late in setting the standards was that it set the standards based on what was actually done.
That's
so it's
correct.
sort of, it's like the following rather than the leading indicator.
That's correct, Judge Pillard, for the years 2020 and 2021.
And that's, I mean, I can't imagine how it could be otherwise. I guess if it's during the year, you could tweak it upwards and just say, play catch up to the regulated parties. But if the standard's not set till after the year is entirely over, there's only that one choice, no?
I think EPA could take into account if it wanted the RIN carryover bank in determining, but it hasn't. Here for 2020 and 2021, the years have passed. The volumes are set at volumes actually used, which ensures sufficient RINs for compliance by all obligated parties.
And the volumes actually used would then be the volumes that are being blended based on the prior year's percentage? Is that how it happens in practice?
Your Honor, I'm not entirely sure exactly how it's calculated. My understanding is that it's the amount of renewable fuel actually introduced into.
But somebody's introducing.
Yes, correct.
And they're having to blend for every gallon sold, like we buy at the pump.
Correct. That's my understanding.
But why did you limit your answer to Judge Pillard to 2020 and 2021? Is there a year for which EPA didn't base it on actual experience?
2020 in 2020, it was not. It wasn't a completely retrospective rule. It was.
Oh, I see.
It was signed on June 3rd, and so it has forward-looking components to it.
But then for anything that's retrospective.
Yes, I want to reiterate that for 2020 it was initially promulgated prospectively, but looking back, given the disruptions to the transportation fuel market, given COVID-19, that amount was reduced to the amount actually used. And then 2021, the year passed by the time the annual rule came out, and that was set at the actually used.
But isn't the other part of the answer to why it isn't always set to the amount actually used is because if it's set prospectively, as I believe it was for the 2019 year, it determines how much is actually used.
That's correct.
And it can push. I mean, this is all a supply push rather than demand pull program. And so they're saying you're required to use these higher proportions, and therefore that's going to be the compliance amount.
That's exactly right, Your Honor. When it's prospective, there's a market forcing element to it. That is driven by increasing volumes set in the statute in O2B. And for this reason, and this is one of the reasons that I think the refinery's argument that the price was caused by EPA delay in issuing the annual rules is not correct. As the volumes increase, the price of the renewable fuels goes up, or the price of the RIN goes up, excuse me. Going back to the...
What would you point to? Your opposing counsel pointed to the GAO report. What would you point to counter? I thought you just said the price spike was not caused by the scheduling.
There's no evidence in the record with respect to what causes the price spike, Your Honor. The GAO report certainly isn't in the record, and in our response to comments, we simply pointed out that it's an extremely complicated issue, and there's they provided no evidence that it was in fact caused any EPA delay.
That means you think the GAO report is wrong?
Your Honor, I just think the GAO report is post-decisional. It is addressing something different from the issues here, and it is not on the record and should not.
And just to explain to me, why is it addressing something different on this issue?
Your Honor, the GAO report is directed to the administration of the small refinery exemption program, which is not at issue, at issue in this rulemaking.
But isn't that what precipitated all of this? Is the small refinery exemption that was? I thought the whole reason for the delay here is because of the or at least a large part of the reason. No.
Part of the reason for the delay was the small refinery exemption program, but in the sense that there were cases pending in the 10th Circuit and then the Supreme Court that would have an effect on the small refinery exemption program and the way EPA viewed it. But also another cause for the delay was that for the first time for the years 2020 through 2022, EPA used its reset authority to set the volumes. And that is a lengthy process that requires EPA to consult with the Secretaries of Agriculture and Secretary of Energy, and to consider statutory factors in order to set the volumes.
In other words, this was a transition period from the statutorily set volumes to EPA set volumes. And so this was a growing pains in the beginning of that transition?
No, Your Honor, there is a transition after 2022 and it addresses the same statutory factors, but there's also a provision that says that if EPA reduces the volumes according to its waiver authority by certain percentages over a certain period of time, it then will reset the volume for future years for which there are statutory volumes according to its waiver once it considers certain factors. So it's the same.
So it chose to reduce the volumes and then it had to do a bunch of recalculations?
Exactly.
Where is that in the? I had trouble figuring out in any of the materials for us why there was the delay, and there was the small refinery exemption stuff which was mentioned in the regulatory materials. Where is? Maybe I just glossed over. Where is it about the reset authority?
I believe it's in the preamble, Your Honor. In one of the first pages, it explains there's the small refinery exemption, and then also resetting the volumes in light, particularly of the reduced use of fuel during COVID-19.
See.
See, I'm running out of time.
If a refiner does not meet whatever the maximum or minimum amount of renewable fuel that has to be added to the regular fuel, it doesn't meet it for the year. Before it files the compliance report, can it adjust by buying up RINs? And it buys them even outside of the compliance year.
Yes, Your Honor. An obligated party can purchase RINs to ensure that it complies with its renewable fuel obligations.
So it can retroactively comply with the requirements.
That's correct, Your Honor. It can purchase RINs that are of the vintages that are usable with respect to that compliance deadline. So for 2020, that would be 2019 RINs and 2020 RINs, and it can purchase those RINs today after the compliance.
I have two other questions that are just for my edification. Are the requirements for the percentage of renewable fuel dependent on the season of the year?
There are, I don't believe so, Your Honor.
Okay. Is there a maximum amount of renewable fuel beyond which an internal combustion engine will not operate?
Certainly, there are certain vehicles where the fuel, if the percentage of ethanol is above 10%, it may void the warranty. And so
I'm not just talking about vehicles. I'm talking about lawnmowers, power blowers,
yeah, so certainly,
2-cycle engines, 4-cycle engines.
I think there are certainly certain vehicles, combustion engines that can't use certain types of renewable fuel, but other types of engines can use, for instance, instead of E10 that has 10% ethanol, E85 that has 85% ethanol.
Thank you.
Can I just ask you to address briefly the argument about the carry forward provision, that the way that the EPA fashioned things in the extension rule
Yes.
counters the carry forward guarantee?
Yes, Your Honor. Mr. Houston referred to the fact that ACE relied in part on the carry forward provision in determining that EPA had reasonably used its authority to issue late standards. And I would point out that the intervals between the compliance deadlines at ACE were virtually identical to those here. 4 months at ACE, here 4 months, and then 5 months. And so the obligated parties still have time, still have the opportunity here to carry forward a deficit, and they can use different RIN vintages in order to comply with that, with the carry forward deficit. So if they carry forward from 2020 to 2021, that means that whereas they used to only be able to use 2019 and 2020 RINs to comply with that, they can now use 2020 and 2020.
And they could do that because of what?
Because of the carry forward provision. And so when they carry it forward, the RIN vintages are the compliance here determines what the RIN vintages they can use. And so if they carry forward, it gives them more flexibility in terms of those vintages.
There is a time at which, the RINs, it's only a 1-year carryover.
Correct.
So if you have, as here, a bunch of deadlines that have been delayed and then bunched together, you're going to have, instead of, let's say you have 4 years of deadlines for compliance filings occurring in 1 year, the RINs carryover is only going to be the preceding actual calendar year, not the year preceding the compliance period, right? I mean, if all is going perfectly, you have the exact number of RINs that everybody needs for compliance, because the whole point is, the only reason there's a market is because blenders are generating the RINs, and the people who have to show compliance are the importers and the refiners, and so they have to buy them from the blenders, right?
Correct.
And presumably there would be a perfect number available and the price would be stable if everything worked as the statute envisioned. But if you have a carryover possibility, but then those RINs expire, RINs could have been created in a year that all those RINs died before anybody needs to use them for compliance. If it was 2 years ago, 3 years ago, 4 years ago, as opposed to just last year. Is that part of what you understand to be the case? Their complaint? And if so, what's your response to that?
I don't understand petitioners to be arguing that RINs that were generated in 2018 and could be used for compliance in 2019 now cannot be on the September 1st, 2022 deadline for complying with their.
Can they be used or not?
I believe so, Your Honor, but I can't.
Because I thought he was saying that when there was a remedial moment when EPA gave back everybody's RINs, but they were useless because they were too old.
Well, in that situation, Your Honor, the compliance deadline had come and passed in the particular instance where he's talking. And so what Mr.
So
Houston,
getting back the RINs that you've saved up, it's sort of like the person who was careful in the face of the exotic mortgages, and managed to stay afloat doesn't get relief, and the person who was reckless gets relief. I mean, I think they're sort of saying that there are disincentives to being conservative in your banking of RINs, because if you get relief at the end of the day, you've paid for something that's then useless. And so I guess seems to me a big part of the equities of their case, and I'm not entirely sure what EPA's response to it is.
Your Honor, I think that it's not applicable. It's not applicable here, where small refineries have known since December of 2021 that EPA intended to deny the small refinery petitions, and they've had since that time to be acquiring RINs in order to comply.
Could they comply well before the deadline? Even though EPA is pushing the deadlines forward, could they just?
Yes, they have the option to do so.
And you don't, so if they're still having to comply in March of this year, they're still having to file for the 2021 compliance period, right?
Yes, sir.
The RINs that were accumulated in the 2021 year and can be carried forward to 2022.
That's
Right.
correct, Your Honor.
But they can't be carried forward to 2023?
Your Honor, so the way the carry forward provision works is if assuming that a obligated party is up to date on its obligations, it can carry forward its 2021 obligations forward to 2022, at which point it needs to retire both of those obligations.
You're right. I'm confusing two different things. One is that the RINs, you can use RINs from the prior year, you can bank your RINs, and the other is that you can postpone your obligation.
That's correct.
So can you bank RINs from 2020 and use them to pay in March 31st of 2023? I'm guessing no.
RINs from 2020 to comply with the 2021 deadline
To apply the 2023 deadline that is now the compliance deadline after the extension rule, because the compliance deadline has been moved forward to, the publication of the final standard was moved forward to July 2022.
Yes.
So you didn't even know what the standard was. Maybe you could have complied in July, but you're allowed till March. And I'm just wondering whether part of the market spikes are because the carry forward of your RINs is no longer functional because of the passage of time.
My understanding, Your Honor, is that the March 31st deadline for 2021 can be complied with using 2020 or 2021.
The March deadline is now, it's the compliance deadline for 2021 is now March 2023.
Correct.
Okay. And you're saying you can use 2020
and 2021 is my understanding.
Because it's the 2021 compliance year.
Exactly.
But if it's a compliance year, if it's a 2022 compliance year,
Then the
then you
2020,
can't use
then you can use the 2021 RINs or the 2022.
but not the 2020 ones.
Exactly, Your Honor.
That's helpful.
Thank you, counsel. Mr. Houston, we'll give you 3 minutes for rebuttal.
Thank you, Your Honor. Several points. Judge Randolph, this is not just about a compliance report. We are required to go out and buy something that costs $150 million. That is what the extension rule is imposing on us. And then we have to go out 3 months later and buy something else that costs $175 million. My clients cannot generate RINs. They do not blend. In many cases, in some cases at least, that's because the product that they ship goes through a pipeline that won't accept blended fuel. That's why Congress created a program where we have no choice but to go out and buy these RINs from the parties that generate them. It's a massive obligation. On the text, my friend from the EPA refers to the text. I want to direct the court to 754505D.
But why does that depend on when you have to file your report, whether you have to go out and buy them or not?
The hardship denials is the thing that requires us to buy them at all. But EPA was very late. It repeatedly missed 90% of its statutory deadlines to adjudicate those hardship petitions, which are the thing that determine whether we have any obligation in the first place. Plus, as Your Honor was pointing out in the colloquy with my friend from the EPA, we're talking about EPA putting out a rule in 2022 determining what my clients needed to have done in 2021, in 2020. You know, it's very much a retroactive application.
Before you file the report, you can bring yourself, which would show if you just did nothing and just filed what percentage of renewable fuels you put into the mix, you would not reach the 10%.
Not remotely, or we would be in violation of the statute. We'd be subjected to very severe penalties.
And so you think retroactively you can bring yourself into compliance?
That's what EPA demands of us, Your Honor. They demand that.
And that is by buying these RINs?
That's correct, Your Honor. That's exactly right. But there's a fixed supply.
And then your argument is the more time you have to enter that market, the cheaper the RINs are going to be?
Absolutely. This is what the GAO found, that the amount of time that EPA acts, whether it acts and when, has a very significant increase on the price. And so by EPA.
So if we vacate the rule, it gives you less time.
No, Your Honor. If you vacate the rule, EPA is going to have to go back and do it again. And they're going to have to do one of two things. They're either going to have to put in a new extension rule that reasonably mitigates our harm, or they're going to have to adopt something like the alternative compliance demonstration approach, or they're going to have to do something like the remedy in Kern Oil by giving us a credit.
The rule is an amendment to a requirement that originally was you have to file a report by March 31st of the next year. So if you vacate the amendment, then all that's left is a requirement that you have to file by March 31st of the following year, and which means you're out of compliance.
I'm sorry, Your Honor. If I might just correct you, it's not quite right. It's March 31st for years that have gone by. Without the extension rule, we would have just the statutory deadlines, and those are years in the past. The EPA cannot obviously hold us liable for having not complied when, at the time that those deadlines were in effect, EPA didn't have the volumes out, it didn't have the hardship petitions adjudicated. I mean, I think that's common ground between the parties here. And so what that means is, if the court vacates the extension rule and issues instructions to EPA to carefully study the harm, the real harm that we're experiencing, that's going to mean that EPA is going to put a new deadline in place.
Where do we get the authority to do that?
Well, I think that the court would vacate the rule, and then it should find that what made the rule unlawful was a failure to reasonably consider our harm. That would provide, I think, the guidance that EPA needs to know that it needs to be more attentive to these statutory deadlines going forward and needs to take seriously the harms to petitioners. I think Kern Oil is a really good example. I mean, my friend from the EPA said just buy ratably all the time. Kern Oil did it, and they suffered tens of millions of dollars of losses as described in our brief. And I just want to return, if I might, for 1 second to the text. 754505D says, if for any reason the petitioner wants to carry a deficit forward, it's entitled to do so during the following calendar year. But the extension rules, plain text, says we get to carry forward a deficit only for 3 months, and then we're required to comply. That's a plain violation, I think, of Congress's instruction. The last point I want to make here is just about the GAO report, which is critically important to deciding this case. It's absolutely relevant. The GAO analyzed the very same question that this court is going to consider. Did EPA act lawfully? The GAO studied its process.
Part of the administrative record.
It's not, Your Honor, but I don't respectfully, that doesn't matter, because I'm not asking the court to consider it for that purpose. My point is EPA put out a rule, and in the rule, it made assumptions and it put forward an analysis. We're saying that assumptions and analysis violated the Administrative Procedure Act. The GAO studied that very question, and it agreed with us. It said EPA ran a faulty process, and it made assumptions that have been proven false. That is.
When you talk about the amount of money that the regulated parties have to pay, presumably in a functioning market, they've charged consumers along the way for what they expect to be that cost. So if that is not required by EPA, then don't the regulated parties get an enormous windfall of the same scale of what you pointed to?
No, Your Honor, not at all. My clients, 3 of the petitioners in this case, have stay applications pending in the 5th Circuit and the 11th Circuit. One of them has gotten a stay. They have shown that they face imminent, irreparable harm. If the extension rule stands and EPA is allowed to impose these kinds of costs on us, the damage to my clients is catastrophic. So it's not about, we're not the ones that are reaping a windfall. We are trying to comply, but EPA...
I'm just saying in a functioning market, the assumption in putting the compliance obligation on importers and refiners as opposed to, let's say, blenders, is that in a functioning market, the cost, it doesn't matter where you put that obligation because you'll charge commensurate prices for your product and you'll be able to buy the requisite RINs to cover those prices. So presumably in planning and in setting those prices, that has been taken into account. But then now, if there's relief, I mean, maybe the prices are way higher than was planned for, but some increment presumably was collected with the expectation that one of the costs of this business is the RIN cost. And I'm just saying that it's, the dollar amounts sound large, but it's going to something for which you're collecting money.
Totally understand, Your Honor. The premise of Your Honor's question began with in a functioning market. This RIN market is not functioning remotely like Congress.
I understand that position. Are you saying that none of your clients have, in fact, garnered prices that reflect the compliance prospect?
Yes, I think that's absolutely right. The idea that we are able to pass on these costs to our customers is just not borne out by reality. Again, we're talking about a 10-fold increase in the price going back just a couple of years. So it's like saying, the charge that a pump, charges for gasoline, we all expect that to fluctuate, but the gas company can't start charging 10 times increase and expect there to be no impact on the bottom line. That's what EPA is doing to us. And again, the reason why that's happening is precisely because the market is not functioning. And EPA you don't have to take my word for it. EPA has admitted this. They have acknowledged in the alternative compliance demonstration approach and in the extension rule that there are only a very small number of parties that hold a supermajority of the relevant RINs. So again, remember that the supply for 2021, 2022, it's fixed. No more can be generated. There's a finite number of them. And a supermajority of them, a small number, we're talking about 10, 11 parties, they hold 75% of the RINs. And now EPA in the extension rule is telling petitioners that they have to go to those companies that hold them and buy. The predictable result, as I think any high school level economics student would tell you, is that those companies holding them are going to charge massive premiums for them. And that's exactly what's happening in this market. So none of this is disputed. EPA acknowledges that the RIN market is not functioning, it is not liquid, but the real problem with the extension rule is they're not addressing that. That's the fundamental problem in this market right now. And that's the fundamental reason why the harms are so high. Instead, EPA, what we get is the extension rule, and EPA says, well, we'll just give you a few more months to comply.
And the drop to zero of the number of small refinery exemptions granted in 2019, is that a HollyFrontier result, or why did the number of exemptions granted go to zero for 2021? Because they haven't been decided yet.
Because EPA fundamentally changed the approach by which they were considering those petitions. It's not a result of HollyFrontier. On the contrary, HollyFrontier told EPA to not be so strict, in essence.
And it's also not because it hasn't happened yet. They just haven't.
Oh, that's correct, Your Honor. The EPA has put out a blanket denial. It has said we're denying all the ones that are pending, and we never intend to grant hardship relief again. And we think that's a flagrant statutory violation. In candor, it's a problem for another day. It's another, decision that EPA has put out that we have very aggressively challenged, and I'm confident that it is unlawful. But it's not. But it is a part of the story, as I think Chief Judge Srinivasan mentioned, because it's one of the suite of actions that was late the EPA then needs to try to make up for. The extension rule is their purported attempt to make up for it, to meet the standard that this court imposed in Americans for Clean Energy.
Can I just ask one last
Yes.
question, which is, you said in the face of this massive market misallocation, and RINs are held by a small number of companies, and they're going to spike the prices, all the extension rules gives us is a few more months. But isn't all you're asking for a few more months beyond that?
No, I'm sorry. We're asking for sort of, I think I would say, an entirely new regime. We're asking for EPA in future years, to follow the statutory deadlines, put out the volumes when they're required to, and give us the statutory minimum 13 months of lead time. That will entirely address the problem in the future, and it will allow EPA to get back on track. Then we have a question. Okay, we have a couple of years from
backward-looking ones.
Correct. A couple of past years where where EPA got really off track. The question is what to do about it. Well, again, I think EPA already had a solution in the alternative compliance demonstration approach. If that's not satisfactory to the agency or the court could adopt the same approach as the Ninth Circuit in Kern Oil, and EPA could give us a credit for the difference between when they were late and when.
But that's not a 12-month, 13-month issue.
It's not.
Okay. I just wanted to understand
at that level, Your Honor, we're talking about we know EPA violated the law. They made a mistake. And the question is, what do we do about it? So when you're talking about.
Right. The remedy for that has nothing to do with the 12-month and 13-month is a vehicle for getting it in balance.
That's right. It's not. That's right. That's about a statutory violation that happened in the past. The question is what to do about it.
Have you filed a petition for rulemaking with EPA, making the arguments you're making?
Absolutely, Your Honor. All of the points that we're making about the fact that the RIN market is.
What has happened to that?
Oh, I'm sorry. Maybe I didn't understand Your Honor's question. We submitted comments in this rulemaking.
The GAO report came out in November.
Yes, that's correct, Your Honor.
Of this or second.
2022.
Right, that's new. Have you, and my question is, you come up with all these hardships which I don't, have no way of knowing one way or the other, but have you filed a petition for rulemaking with EPA, bringing these matters to EPA's attention and asking for a rule of the sort that would deal with, you'd have to deal with a heck of a lot more than the extension.
I understand that point, Your Honor. When the GAO report came out in November, it said to EPA, we're sending that. They obviously sent it to EPA and told them, go back and study this thing more. Look harder at this problem. That was the GAO's recommendation to the agency. The agency did that. It put out then in December a new finding that confirmed that we're right, that EPA's assumption built into the extension rule about the ability of petitioners to pass on their RIN costs was wrong, that was empirically flawed.
Is that December report? You didn't mention that.
It came out after our reply brief, Your Honor. But I think all that just shows is that the extension rule, which was put out back in February of 2022, was based on a series of assumptions and an analysis by EPA. We argued in our comments, and we've argued to the court, that those assumptions and that analysis was faulty. The GAO that's the fundamental question I think this court is going to decide in this case.
I've got it.
GAO looked at it and said we were right.
Thank you, counsel. Thank you to both counsel. We'll take this case under submission.